Make sure you have your computer mic off
Oh, thank you.
or muted.
Let me see.
Okay.
Turn my speaker all the way down. Is that okay?
What's that?
I turned my speaker.
That'll work.
Okay. All right. Good evening, everyone. Is this audio okay? Sound all right? No echo? Great. Good evening, everyone. For the record, my name is Angie Brewer, and I'm a senior planner for the Community Development Department of Deschutes County. I'm going to share our screen on this end to initiate the hearing you're all here for this evening. And I'll ask the producer to elevate that screen. Thank you very much. There are two items before the hearings officer this evening. The first is an appeal to the administrative approval of file 247-21000508 SP, the site plan review of 80 overnight lodging units in phase A1 of the Thornburg Destination Resort. The second is an appeal to the administrative approval of file 247-21000553 MC, amending the previously approved conceptual master plan and final master plan for the Thornburg Destination Resort to conform to changes in the state and county rules regarding overnight lodging units. I'll begin the hearing by explaining how members of the public who are joining us by Zoom and telephone can testify. After my Zoom instructions, I'll be turning the hearing over to Hearings Officer Gregory Frank for his hearing instructions. I'll follow with my oral staff report. The applicant will make its presentation, and then the public will be invited to testify. Staff will be afforded an opportunity to make any closing comments, and the applicant will be given an opportunity to present any rebuttal testimony. To be clear, there are two separate public hearings this evening. Any comments made are unique to the hearing they've been shared to. So if participants wish to provide comments to both hearings, they must make comments to both hearings. And we appreciate that there may be some redundancy in this format, but it is required to ensure the records for each case are complete and accurate. Should the county's internet connection be interrupted, we will be attempting to get back online as soon as possible. If this happens, please give us a couple of minutes to activate the public hearing before you attempt to link or call back in. If your own connection gets interrupted, please attempt to join back using the same link or phone number you used initially. I'd like to take a minute just to share with you the difference in the two different ways that we can have you participate by Zoom, either as a panelist or an attendee. In Zoom, these are two different categories and you have different abilities as those participants. As a panelist, your microphone and your microphone and your video will be active for everyone to hear and see you. And also as a panelist, you have the ability to mute your microphone or turn off your camera in the event that you need privacy or you don't wish to share those. As an attendee, your video is not active and the county's producer controls your microphone. This is an important distinction because anyone wishing to testify by Zoom will be prompted to be a panelist so that your audio and video can be recorded. For the microphone, let me advance my slide here. There's some images here to help those that are new to Zoom. You can see that there is an icon for microphone and an icon for your video. You can toggle those on and off by clicking on them. And you have access to those in the panelist format. This is important to note in the event that you need to confer with your legal counsel and you wish to be muted or have your camera off at that time. Any attendees who wish to testify, what we're going to do is right now, we're going to be asking for those who are interested in testifying to participate in a little exercise where we will elevate you all to panelists. We will ask you to raise your hand if you're interested in participating. And one at a time, we will be asking the producer to elevate you so that we can open your mic up and allow you to tell us whether or not you're interested in participating in favor of the proposal, neutral to the proposal or opposed to the proposal. I should say that the appeal, excuse me. And we'll be calling you out one at a time. So I'm going to, at this time, ask the producer to elevate each of the individuals who are participating to panelist.
Would you should let those people, ask everyone to raise their hand if they would like to present tonight.
Sure, thank you. Sorry about that, folks. We're clarifying procedure here. If you're interested in participating and in the act of providing testimony, please raise your hand so that we can elevate you to that status. Is it appropriate for me to begin calling names? Yeah, okay. I just want to make sure. All right, so at the top of my screen, I see Mr. Ken Katzeroff. Do you wish to provide testimony?
As applicant's co-counsel, yes.
Thank you. I see Carl Anuda.
I will be providing testimony on behalf of Ms. Gould, along with Mr. Klein.
Thank you. I see Mr. Kleinman. Do you have anything you'd like to add to that? You're on mute.
Sorry, as Ms. Gould said, I'm sorry, as Mr. Nuda said, I'll be appearing on behalf of Ms. Gould, the appellant.
Thank you. I see Cameron DeLashman.
Yep.
Do you wish to provide testimony yourself as part of the applicant's testimony?
Yes, I will.
Thank you. All right, producer, is there anyone else that you see on your end?
So Nunzi's there.
Oh, that I didn't, let's see. Isn't Annunziata Gold? There you are. I see your hands
Yes,
up.
I'd like to testify also on both issues. Thank you.
Thank you. Anyone else I may have missed? Oh, interesting. I can't see all of those. Christine Larson?
Yes, I would like to testify on both.
Thank you.
Jerry Cullen.
Jerry Cullen?
Yes, I would like to testify against on both.
Thank you.
And we've got Paula Latza.
Paula Latza?
Latassa, thank you. Yes, I would like to testify on both.
Susan Strauss.
Susan Strauss? Yes, I would like to make some comments on both.
And did we get David Arnold yet?
And not yet. David Arnold?
Yes, I will be testifying as well.
Thank you.
I think that's everybody. Let me check again. Oh, he put it down. Okay. Just ask them to confirm that we've got everybody.
Thank you, everyone. Did I miss anyone? Did we miss anyone?
Yes,
Yes.
Oh,
Can you
Liz.
state your
Me.
name?
Liz Fancher.
Okay, thank you, Liz. Can't see you. Okay.
Right, name's there. Sorry, now you can see me maybe.
There, I see you. Thank you.
And
Anybody
I'm
else
not-
out there?
Oh, I was just gonna say, I'm not necessarily going to testify. I'll only testify if I think it's appropriate to join in, and perhaps only in rebuttal.
Okay, thank you.
And just Carol Macbeth.
And Carol Macbeth. You wish to provide comment?
She's muted.
And you're on mute. I'm sorry about that.
Yes, we will make a comment.
Thank you. Okay, thank you. Confirmed on this end, we don't see anybody else. But if we've missed you, please let us know. I think you're still all elevated at this point. Okay. Thank you very much. We will return you to attendee status. Thank you, producer. All right, so from there, producer, do we have anybody on the telephone? One on the telephone. Can we elevate that person and confirm? Thank you.
Your number is ending in 3394.
Thank you. Caller with ending the last four digits 3394. Are you interested in participating?
And they're muted.
Oh, and you're muted. And by phone, I believe you have to dial *6 if you've dialed in. And I'm not hearing anything. Not hearing anything. If you're able to call back in again, perhaps and try to see if it unmutes you. That would be a recommendation, or just or participating by the link instead. Okay. All right. Well, I think we're gonna put everyone back in attendee status and keep moving. I appreciate that. Thank you all for the exercise. It's my first time navigating this this format, and it's new to me. So thank you for the patience. All right. So I'm going to move us on to the next slide. If you wouldn't mind putting my PowerPoint back up, I'd appreciate it. We are going to be, let me get back to that so I can see it too. So we have, we're hoping to have an orderly hearing here this evening. It's going to be 2 hearings back to back, which is likely to be a longer evening. So what we're hoping we can ensure is that we stick to this process as much as possible. If you're interested in providing testimony, obviously we just went through the process for how you participate verbally. If you have written testimony, you can provide that to us physically tonight. We don't have anyone in the room with us, but if there is anyone that walks in later, they can hand it to us personally. You can email it to me directly. My email is on the screen, and you can mail it to us, and I'll provide that information towards the end of this hearing. So we respectfully request that this is that the behavior tonight is respectful and on topic, and please note that any testimony or behavior that's inappropriate will be addressed, and we may have to remove that member of the public if they're being unruly or disrespectful. So let me see where I'm at here. Please note that if you do provide anything in writing now or later before the end of the close of the record, if it's more than 20 pages in length, includes any color figures, or is oversized by any means, we will also need a hard copy of that material. And again, I'll provide our address towards the end of this hearing. All right, so given all that information, do we have any objections? Does anybody have any concerns about this format? You can raise your hand now if you'd like to make express any concerns. Ms. Gould has raised her hand with concerns about this format. Could we please elevator? Thank you. No, you're fine. Those of you that can't see all of us, there's multiple staff in the room and we're navigating this together.
I have a procedural question. This is the first time I've ever seen 2 separate appeals heard at the same hearing at the same time. And what I think is important is that these records be managed appropriately by the county. So my question specifically is, where is the county record held? What is the county record these days in the pandemic?
Well, so these are 2 separate hearings held in one evening. The records are being maintained individually. There's no change to our process as far as record management goes.
So is there a hard file that the county is keeping, or is it a digital file? Does the hearings officer get the hard copy file? Or how does the hearings officer get the file these days?
Ms. Gould, let me respond to the question regarding how I get the file. I access through the state building permit process, which is online. And I will talk about that in my opening comments. The county does not, as a matter of routine, provide me with a hard copy. Only on once or twice have I actually requested a full hard copy set. But I will talk about what I look at and what I can see during my comments.
So I'm just trying to understand, since the Excella program accepts documents digitally and in color, why is there a reason to be delivering all of this material to the county? And why is there a limit on 20 pages where you have to come in during the face of a pandemic to the county? I'm not understanding that step anymore.
Ms. Brewer, I'll allow you to answer that one.
Thank you. There are some limitations to the programs we use for uploading documents into the Acela database. When they're uploaded and translated in some ways from one program to another, they lose their color. And we're working on that. We are working on solutions as to how to mitigate that issue. But if color is important to the exhibit that you're proposing, that you're providing, we encourage you to provide it to us in color so that the physical record is retained as intended. You don't have to visit the office in person. You can mail it if that's your preference. But that is my understanding of the issue, is that it's largely database related as to how it translates from.
The Excella is a color system. It's the dial system that's black and white. So I'm just trying to get real clarity on where is this record held within the county, so that people who are looking for things don't have to waste their time. Right now, on this one hearing, they would have 2 separate files to be looking at on Excella, possibly 4 separate files to be looking on. And I think since the county has not actually issued a specific link to where the public can find these things, it puts the public at a disadvantage, especially where those people don't do this land use stuff on a more regular basis as the planning department or the hearings officer might be doing. So my concern here is when a link is sent under building permits, we're not issuing building permits here. We're issuing, review under a planning process and a planning permit. And so even simple things like that mean the public has to know even how to navigate within these things. So I think it is important that we have a link that sends people to the actual file and that they don't have to go around the world to find it. So that's my general comment regarding the record and the onus on the public to be bringing in color documents. I think that's kind of stupid. I mean, we already have applicants and rebuttal people submitting color documents that are getting uploaded to Excella just fine. So I don't see why the public should be put through some other ringer on this. That's kind of the antithesis of goal 1. Thank you.
Mr. Hearings Officer?
You're on mute.
Oh, I'm on mute. Is my mic live here? There we go. If I may, Mr. Hearings Officer?
Go ahead, sir.
Thank you. Ms. Gould, you are correct, and the official record for the purpose of this hearing will be the Acela ACA site. And that's where the record is, that's the official record that will be retained, presented to the hearings officer, and ultimately presented to the board. We're in a transition period here I don't want to try to convince you in any regard that the Acela site is ideal, and we're actually trying to work to find better ways to present that right now with our IT department. The ACA site is something that was given to us by the state, and we're trying to make that behave itself better. It's easier for us to take electronic submittals, but we've been concerned that people may have trouble uploading them or may believe they've sent something that they haven't sent. So we're encouraging people to bring large files, which are those most large and color files, which are the most likely to get glitched in the email system via paper copy. And that continues to be our recommendation. If you email something to us and we receive it electronically, we're certainly going to include it in the record. But there is some chance that it either doesn't arrive whole or doesn't arrive at all if it's too large through the email system. So we encourage you to continue to provide paper copies.
Then I just have one final question, which is, what is the expected delay between when somebody submits something electronically to the county and when that document is available to the public for viewing on the Acela site?
We're currently targeting 1 business day for that. We have, unfortunately, our admin professional has taken another position, and we're definitely short-staffed at the moment. But we're emphasizing getting these out over to there as quickly as possible. And so if you at any point have a question about what's available, you can certainly email the planner here, Angie, or myself. And to your question about how to operate the Acela ACA site, I too admit that that's relatively difficult. And so if you email planning@deschutes.org, we'd be glad to take a time to coach you or anybody through how to access files through that site during the time when we're trying to find some more reasonable way to present that information.
Thank you.
Thank you. All right, if there's no other objections. Oh, thank you. Thank you, producer. Hearings officer, we have one more objection. Mr. Carl Anuda, you elevate, please.
I had a question for the planner. If we've submitted electronic documents already that are over 20 pages and in color, do we need to still, is there some way to tell whether the county's got those in complete form so that I don't waste your time sending you another hard copy paper set? If you've already got the electronic set that came through just fine, is there some way we can clarify that so that you don't have multiple sets of this stuff?
If I may, Mr. Hearings Officer. Just checking my mic
Right,
live
sir.
here. Thank you. So if you send us something electronically, please be sure to ask for confirmation of receipt. Your best bet is to take a look on the Acela ACA site. That's your sign that the file was received by email and Acela has properly swooped it up into its loving arms.
It's also an opportunity to view what you've provided. When we're receiving a lot of documents at the same time, we do our best to shift them from, received to uploaded as fast as we can. And sometimes it's before we have a chance to even read them ourselves. And so it's a good chance for you, if once it's uploaded in the site, you can view it to make sure it's what you want it to look like, what you intended it to look like as well.
Great, thank you.
Thank you. Okay. All right, Mr. Hearings Officer, this is my cue to hand it over to you to introduce your format that you'd like to follow. And then when you're ready, I can share a staff presentation.
Thank you, Ms. Brewer. For those of you in the audience, my name is Greg Frank. I'll talk shortly about myself, not because I'd like to talk about myself, but to let you know what I'm aware of and whether or not you believe that I should be hearing this case. So we'll talk about that shortly. I want to follow up ever so briefly on Ms. Brewer's last question, which both Ms. Gould and Mr. Anuda provided input. The question was, is there an objection to the format? And that is a question, is there an objection to the Zoom format of the hearing And I want to just double check because I believe both Mr. Anuda and Ms. Gould raised issues about the record in and of itself, but not to the Zoom format. So if the producer could do me a favor and make sure that folks can raise their hand if in fact they're objecting to the format, that means the Zoom format of this hearing.
Seeing none.
There are none.
Thank you. All right. And before I get into my formal opening comments, I want to respond to both Ms. Gould and Mr. Anuda's concern about the record. For those of you, and this is not meant to be directed necessarily to those folks, those two individuals, but to everyone else who is going to participate or is just listening tonight and is not going to testify. If you have any questions about how to submit a document, my suggestion is that you either email or contact Ms. Brewer directly and ask, how do I do this? Because I too, when I first started doing hearings for Deschutes County, found myself a bit confused as to how I accessed information and whether or not I was looking at complete information. I feel more comfortable now, but if you in the audience have any questions whatsoever about how to submit documents, we're going to bring it up, I'm sure, at the end of the hearing again. But if you even then are unsure, please contact Ms. Brewer. And if you know someone else who isn't participating tonight or listening tonight, please communicate my sentiment that they should be contacting the planner and to get specific instructions, because I want to make sure that the record includes everything that those folks and you want in the record. So let's talk about my formal comments, and I apologize if they last very long, but there are some things that I just want to make sure you understand. First of all, this is a recorded hearing. And so hopefully everything I say and everything you say tonight, if you testify, is included in the recording. I'm going to reiterate what Ms. Brewer indicated, and that there are actually two separate hearings tonight. One will follow the other. The first one is 247-21-00508-SP, which has an appeal case associated with it, 247-21-00849-A. This relates to overnight living units being proposed by the applicant for the Thornburg Resort. So that's going to happen first. And we will take testimony on that first. And as an aside to Ms. Gould's comment, the record should be exactly the same as if in fact we held this first hearing tonight and we on a separate night heard the second hearing. The record should be separate, and we will hear the 247-21-00553-MC with the appeal MC, or excuse me, 247-21-00920-A. We will hear that one second. And that was a matter of both hearings officer efficiency, but also staff efficiency as well. And I know it may go longer than on this particular night, but in my understanding or my expectation is it will not last longer than the two hearings would have if they'd been held on separate nights. You have every opportunity to testify at either one or both hearings. The evidentiary records for these two hearings are separate and distinct. If you want written evidence or testimony to be included in both records, then you're going to have to submit the information, the evidence, the testimony at both hearings or in both files. Please be aware of that, is that I will not, and I'm sure I would if I was participating in the first hearing, simply tell the hearings officer, would you incorporate my comments and my testimony into the second hearing? And I'm going to tell you, as a matter of clarity, you must submit the information, both testimony and written evidence, in both files. All right. So my name is Greg Frank. I am a hearings officer. I'm on contract with Deschutes County as well as other jurisdictions. I would like to tell you what I already know about this case, including the people and the property involved in these cases. I have not had any prior contact, or excuse me, hearings with Deschutes County Senior Planner Angie Brewer, who is the primary representative in both of these cases tonight. My contacts with Ms. Brewer have related to scheduling and hearing procedures, including those related to this Zoom platform that we're involved with tonight. I have also reviewed briefly, but not in detail, all documents submitted into the public record through 2 p.m. today, November 4th, 2021. So if something was submitted late and didn't get onto into the electronic record, I may well not have seen it. I have had no direct in-person telephone or electronic communications or contacts with any person related to this case, excepting that I have had one phone call with Ms. Brewer and Mr. Groves related to the hearing process. I want you to be aware, if you weren't at an earlier hearing involving the remand of a case from Luba involving Thornburg, some of you as participants in that hearing are totally aware that I recently issued a decision related to the resort dealing with the Luba remand of the Thornburg tentative phase A1. As I did in the Luba remand case, I will review the relevant evidence submitted into the record of both of these cases, in particular the one we're dealing with now. But please be aware that I will only consider evidence submitted in if there was evidence submitted in a prior case, the one that I've already decided, that evidence is not going to be considered by me unless it's been resubmitted into the evidence of this and the second case tonight. So if you think something was important involving the earlier case, the tentative plan phase A1, then you're going to have to resubmit it tonight. And I know it seems redundant, but it's very important for the clarity of the record. I'd like to talk about how long this is going to go tonight, because I'm looking at, as a panelist, I have access to, I'm not sure what you see, but I can see that there's at least 30 attendees, and a fair number of you have indicated you're going to testify tonight. And so with that in mind, and I'm fairly confident that someone is going to request the record to be remain open tonight. So I'm going to make a suggestion regarding time limits regarding testimony tonight. And I will give anyone who wishes to object to that an opportunity. But my suggestion is that the applicant and applicant's team, in other words, all applicant testimony, will have a 30-minute time limit. The appellant and the appellant's team will have a 30-minute time limit. All other persons, whether in support or opposition, will have a 5-minute limit. I'm doing that because I truly believe that the record is going to remain open. And if that's the case, I don't believe that setting these time limits is going to impose any undue hardship on you getting information to me in a format that I will consider and review in detail. So if the producer would do me a favor, does anyone object to these time limits that I'm suggesting?
I see Ken Katzroff with a hand up. Please.
Sure, thank you. Mr. Hearings Officer Ken Katzroff has his hand up.
Okay, Mr. Katzroff, floor is yours. You're still muted.
I don't have an objection necessarily. I think we can probably make it work. I just want to clarify that that would not include rebuttal time by the applicant.
No, it does not.
Okay, thank you.
And I will, if as the evening proceeds, if I believe that there needs to be a limit on any rebuttal testimony, whether it be from you, your team, or the appellant, I will discuss that prior to opening up the testimony for rebuttal.
Okay, thank you.
All right. So with that in mind, the time limits are going to be 30 minutes for the applicant's team, 30 minutes for the appellant's team, and 5 minutes for everyone else. Just, and you can think this, take it how you wish. When I said a 30-minute time limit, that doesn't mean that you have to use the entire 30 minutes. And if I said a 5-minute time limit, it doesn't mean that you have to use the entire 5 minutes. But we'll talk about that a little more. I want to also tell you that oftentimes hearings officers in land use cases do site visits. That means they go out and physically look at the property that's subject to the hearing. I have not conducted a site visit. I didn't do it on the prior case. I won't do it in this particular case. Shoot, this sounds like a very large piece of property. I'm not sure I'd know what I was really looking at. So my awareness of the property in this case is going to be limited to my review of the materials in the public record, and I think that's to everyone's benefit. I will tell you that I do not own any property that would, excuse me, directly or indirectly, at least in my opinion, be impacted by any decision issued in this case. I do not have any personal, business, social, economic relationships, excepting for my hearings officer contract with Deschutes County with any person or entity associated with this case. As an aside, as I indicated in the earlier hearing regarding Thornburg, I have had prior hearings with Mr. Kleinman. I've had prior hearings with Mr. Groves. And I do not believe that that impacted my decision in that case in any way, shape, or form. So that's who I know. The documents that I've reviewed in this case so far, as I indicated, I made a cursory review of the public record as those documents were uploaded as of today at 2 o'clock on November 4th. I will note that I have read the entirety of the staff or administrative decisions for the site plan and modifications proposals. And these documents are available for you online. My job in this case is to consider all laws, whether federal, state, or Deschutes County, that are relevant and apply to the case. And in that context, to consider all relevant testimony and written submissions. The task of a hearings officer is to confirm what laws are relevant and then consider the testimony or the relevant evidence in relationship to those laws. At this time, I'm going to tell you that I believe I have no personal bias or prejudice in matters related to this case. I believe that I can make an objective decision in this case. Once again, I'm going to ask the producer, because I'm going to ask a question of you all. I'm going to ask you whether or not anyone has an objection to me hearing and deciding this case because you believe that I have a bias or conflict. If you do, I need you to raise your hand.
And seeing none.
We don't see any on this end, hearings officer.
Okay, thank you, Ms. Bird. So I will proceed to consider this case and make a decision in this case. The burden in this case, the applicant has the burden of proof that it is entitled to its proposal. That comes right out of the Deschutes County Code. Testimony this evening should be directed towards the laws or rules or standards set forth by the planning staff in its decision and notices, or If you believe that additional or different laws or rules or standards or land use decisions applies, please clearly identify for me the additional or different laws, rules, or standards or land use decisions. The decision I render in this case is required to be made based upon the relevant approval law and criteria, not what I like, not what I desire, not what I dislike, but on the relevant laws or rules. I'd also, since there's still 30 attendees and a fair number of testimony folks, I'd like to talk about repetitious testimony. And this is something that comes up in numerous hearings. Since a fairly large number of persons wish to testify this evening, in consideration of everyone's time, I would ask that if someone has already made your point or expressed your views, so that I would ask that you indicate, for example, by saying, I agree with that person, or I support that person's position, that would be very helpful. There's an old saying that I find appropriate, and that saying is that if you say something or make a point more than once, it does not make that something or that point any more true or any more false. I consider all testimony and all evidence in the record when making my decision. I am not inclined to find a point or an argument more persuasive if it is made more than once. It is the substance of the point or argument that is important to me. All right, a couple things that I have to say, and I say this at every single Deschutes County hearing, but I'm just going to read this part, and I apologize if it bores you, but it's really important. It is failure on the part of any person to raise an issue with sufficient specificity to afford the hearings officer, that's me, or the parties to this proceeding an opportunity to respond to an issue will preclude an appeal on that issue. Additionally, failure of the applicant to raise constitutional or other issues relating to the approval with sufficient specificity to allow the hearings officer to respond to the issue precludes an action for damages in circuit court. Let's talk about the order of the testimony. I think Ms. Brewer has already sort of gone over that briefly, but let me do that once again. First of all, after I complete my comments, which are almost done, staff will present a summary of the administrative decisions. Next, the applicant and the applicant's team will testify and present any additional evidence. After that, any supporters of the application, those who generally agree with the application or position, will be given an opportunity. Deschutes County is relatively unique, in my opinion, is that their next set of persons who testify are those who are in a neutral position. And I find that there are usually not very many people in the neutral position. They're either for it or against it. But if you are truly neutral and you have information you think is relevant to me, that's going to be your opportunity to speak. Next, the opposition or the appellant in this particular case, the appellant's team will be given an opportunity, and then anyone else in opposition will be given an opportunity. After that, I typically allow staff their closing comments, which is typically not what staff likes to hear because they like to go last always. But I ask staff to give their closing comments, and then I allow for applicants' rebuttal. I will allow a appellant time period for rebuttal, and then I will close with an applicant's, for lack of a better term, rebuttal. If staff has any final comments regarding process or procedure, I will then ask staff to respond to that. Last thing I have for you is a request for the record to remain open. As I indicated earlier in my comments, I fully expect someone to say, I want the record to remain open after the conclusion of the hearing tonight. You have every right to do so. This request only needs to be made once. So if somebody before you testify has already made a request for the record to remain open, that the record will remain open. If the record is to remain open, it will remain open not less than 7 days for the submission of new evidence, not less than 7 days for final rebuttal. Deschutes County has a slightly different process. Typically what happens is that it's a 7-day evidence, 7-day response to the evidence or rebuttal to the evidence, and then a rebuttal period for the applicant. So if someone asks, we will talk about that. I will bring up at the end, if somebody does make such a request, I will get my calendar out. I would hope that you get your calendar out, because what we'll do is we'll figure out when the open record periods are the end. And I will discuss it. And Ms. Brewer, if in fact it comes up about the open record period, submission of evidence, we will talk once again about the submission of evidence during the open record period and what the time limits might be. So with that, Ms. Brewer, the floor is now yours. This will be the time and the place for the staff presentation. Following that, I would expect the applicant or applicant's team to be prepared to give their testimony. Ms. Brewer?
Thank you, Mr. Hearings Officer. And I'd like to acknowledge for everyone on that may be watching, and you as well, that we've had quite a few people join us after we went over the opportunity to identify themselves as interested in providing testimony. So if it's all right with you, I'd like to have the producer open that opportunity back up and let anyone who's interested in providing testimony that has not already identified themselves raise their hand, and then we can.
That's fine with me. Go ahead.
Okay, thank you very much. Anybody on the phones?
We picked up one more phone call. It's 2717.
All right, it does not appear that anyone has raised their hand. We do have one phone caller, last 4 digits 2717. If that person is able to speak, or have they been elevated yet? Yeah. Caller, if you are interested in providing verbal testimony, could you please let us know? Okay, thank you. I'm not hearing anyone on the phones. And we also had Carolyn Wise raise her hand in the meantime. Carolyn, are you interested in providing verbal testimony? You're on mute. I think I hear you.
Okay, yes, I am.
Okay, we'll make
Can you
note
hear
of
me now?
that, and when we get to that time, we'll call on you.
Okay, thanks.
Thank you. Okay. And all right. All right. Thank you, producer. Let me just make this note. All right. Is there another hand up? Carol Macbeth, are you interested in making another statement about providing testimony? Oh, perhaps her hand is up in error. Don't see her.
Yes, I would like to testify this evening. Is that the question?
There were a few late joiners. I just wanted to make sure we give them the opportunity to identify that they were interested. So thank you for confirming though. Okay, Mr. Hearings Officer, I think I'm ready to give you a short but sweet overview of the staff reports. We did not prepare a new staff report for this hearing, so this will be a relatively short summary and a bit redundant with what you've shared already. Let me get my PowerPoint to the right slide here. So the first hearing of this evening, as you noted, Mr. Hearings Officer, is related to file 247-21000508 SP, and the appeal file associated with that is file number 247-21000849-A. And that is with regards to the administrative approval of 80 overnight lodging units that were proposed as a means to implement part of the development conceptually approved and actually required by the resort's final master plan. The applicant is the Central Land and Cattle Company and Cameron DeLashment, as represented by Liz Fancher and Ken Katzeroff, and the appellant is Annunziata Gold, represented by Jeffrey Kleinman. And just briefly, I just want to make sure we reference that we will be relying on the applicant and the appellant to summarize the unusual history and the items on appeal here. There's a site plan for just general context for folks to know where this part of the development is proposed, and that it is proposed on lots identified in a tentative plan that is currently in review. These are a couple of images just for, again, for context of what these overnight lodging units would look like. They'd be in 24 cabins. And just a quick summary of the items on appeal, the reasons in the appeal application. The appellant has concerns that the site plan cannot be adjudicated or relied upon until the items on appeal in file 731A are resolved, which verifies the establishment of that subdivision. There are some concerns that the alternative plan to approve this development would require substantive changes to the conceptual master plan and final master plan, which requires a new review. There are concerns expressed about error of incorporation by reference, the golf course and lakes decision from 2019, and also concerns regarding the overnight lodging units themselves. So that is a very quick summary of the staff report and the appeal. And I'm happy to field any questions from you, Mr. Hearings Officer, or allow us to move forward.
I have no questions at this time. This will be a time and a place for the applicant or applicant's representative to make the presentation on behalf of the applicant. Ms. Brewer, with that in mind, I'm going to officially designate you as the timekeeper. And you can start your 30 minutes when they start their testimony.
Sounds good. Thank you. So I think now we will be, producer, I think we'll be elevating Ken Katzeroff. Is that correct? Ken, are you ready? Okay. Sorry, Ken, it's processing.
It always takes a minute to go between panelists and attendee. Sorry about that. All right, for the record, Ken Katzeroff. I am co-counsel for the applicant. My address is 1420 Fifth Avenue, Suite 3400, Seattle, Washington, 98101. Given that we do have some time constraints now, I will try to be as quick as I possibly can. That tends to mean that I talk fast. I will attempt to moderate my remarks to be conducive to the time limit. I'm going to give a couple of general comments and then address a few specific issues that the appellant has raised. I want to say for kind of everybody who's on the line and listening that Thornburg has been in a land use process since 2005. There has been extensive litigation related to the conceptual master plan or CMP, as well as the final master plan or the FMP. The FMP is the governing document at this point in time that authorize all resort uses, including the OLUs or overnight lodging units that are subject to the site plan approval today. Given this framework, that is what is required. Just a site plan approval for overnight lodging units. That's what we're here to talk about. Ms. Gould mentioned that goal 1 is served by the public process. We fully agree. I'd like to say that goal 1 has been very well served throughout this process. There has been a very robust public process, again, since 2005, that has included review before the Board of County Commissioners, to the Land Use Board of Appeals or LUBA, and to the Court of Appeals, and frankly, the Supreme Court on many occasions to at least some or all of those bodies. I will note that goal 1 is not served, however, just by relitigating each and every issue already decided. And case law has has frankly settled a lot of the issues in the process related to the CMP and the FMP. Those conditions, those decisions, et cetera, may not be collaterally attacked during this site plan review process. So again, arguments raised here, hopefully hearings officer and staff has said this should be related to the site plan itself, and that certain issues that have been conclusively decided before, such as availability of water or meeting the no net loss standard in the code, don't apply. We have to meet the conditions imposed, but that's it. Okay, now with regards to those specific condition, in particular, the conditions of the FMP, which we must show compliance with, I have one issue to raise. And that is that the conditions that have been identified in the staff decision mistakenly identify certain conditions from the CMP as conditions of the FMP. This may be a little bit confusing. I just note that page 33 of the administrative decision, as well as the BOCC's golf course decision, kind of reiterate which conditions actually apply. And so we're talking about conditions of the FMP here, not conditions of the CMP. All right, those conditions that were in the CMP were determined to no longer apply and were incorporated into the FMP. The reason this matters is that certain conditions have determined to be satisfied and no longer apply, and certain conditions have frankly been replaced with different conditions. So for example, Appellant Gould has raised issues with condition 28. Condition 28 no longer applies. It is gone. It has been replaced by conditions 38 and 39 of the FMP, and were imposed to meet that standard instead. So any arguments related to condition 28 are properly rejected because it's simply not a requirement that exists anymore. I'm happy to answer any questions about that. Otherwise, I'm going to continue to move forward. So that's the first correction that I just want to raise. The second one, and hopefully when the hearings officer is drafting a decision, he addresses the proper conditions from the FMP. The second condition, or the second thing that we would request a correction on, is that we believe that staff erroneously imposed condition A on the decision and condition C. And those are conditions related to this particular decision themselves. Why this matters is condition A is a pretty standard condition that I've seen in, I think, every land use decision, not just across the state, but in Deschutes County, which says that any substantial change requires a new application. That makes sense. Condition C, however, prohibits any change to the site plan. I've never seen that in another county approval, really anywhere. And frankly, it's a little bit unworkable from a perspective of both development and enforcement. And that's because a site plan is not meant to be the absolute specific, completely granular document. It doesn't provide legal descriptions or an as-built or anything of that nature. And so it makes it impossible to completely comply because it's a more generalized document. It obviously requires us to meet the code under 18124 for site plan review, as well as the destination resort site plan code. However, it is not intended to be the final document that no itty bitty minor changes can be made. So we would ask that condition C be removed, and that the hearings officer relies upon condition A, which is the standard condition, frankly, in I think every decision I've ever seen for land use. I'm going to change or move forward and talk about specific issues raised by Appellant Gould at this point in time. The first is that Appellant Gould claims that the site plan is inextricably linked to the Phase A1 tentative plan, and so it shouldn't be approved. Ms. Gould has argued this in many previous forums, including during their review of the Phase A1 tentative plan. And this argument has failed. It simply they're not inextricably linked. To the extent there's any link, it's because they were both authorized under the FMP, and we are now developing a use that is allowed by the FMP. Nothing requires that the OLUs be on separate lots at this time, and staff has appropriately conditioned this decision to address this issue. So this idea that it's inextricably linked has been rejected previously and should be rejected here again. The largest portion that I'm going to talk about today is, I think, what a lot of folks are going to address, which is water. Water is addressed under two main conditions as it relates to the Thornburg Resort. First, it's condition 10, and second is condition 38. What I would say as kind of a preface is that Ms. Gould is attempting to relitigate the purpose, the intent, and the interpretation of condition 10 of the FMP. Previous hearings officer decisions, the BOCC and LUBA have all opined that this condition is related only to the consumptive use of water and that it's an informational requirement. We have to provide information about the water right and about the mitigation that is required under that water right. The hearings officer, we requested he apply the interpretation that has already been determined to be legally correct by LUBA. For what it's worth, Thornburg maintains a valid and existing water right that's non-canceled and may serve resort for consumptive water use purposes. Ms. Gould is challenging that right, in particular an extension, but it is still held by the resort. It may be used. And OWRD, or the Oregon Water Resources Department, has taken no steps to cancel it or make any other findings that that water right can't be used. Also, for what it's worth, LUBA has determined that there is a standard that is applied for water use in the land use review context, and that's the standard articulated in the Bowman versus Jackson County case, which is 23 or LUBA 628. And all that really has to happen when you're reviewing water use in the land use context is that you show that you're not legally precluded from securing that right. Well, Thornburg has already secured the water right. Again, Ms. Gould is challenging it, but we still hold it. It's non-canceled and it may be used. Again, condition 10 is an informational requirement only. Applicant has complied with that, and the hearings officer should not come to a different interpretation than that reviewed and upheld by the BOCC, LUBA, and the Court of Appeals. I'd like to chat a little bit about this idea of mitigation. Ms. Gould seeks to confuse what the term mitigation means in the context of water. There is two types of mitigation that we're talking about here. Condition 10 has no relation to the mitigation required under the FWMP, or Fish and Wildlife Management Plan, which deals with the no net loss standard. In fact, condition 10 was imposed before the FWMP was adopted or even written. It was imposed as a part of the CMP originally. So when we're looking at this and we say mitigation, it means two different things. LUBA has determined, frankly, in its last review of the golf course decision, that the FWMP and mitigation under the FWMP is related to fish, streams, and wildlife. And that type of mitigation is addressed by condition 38, not condition 10. What's important about condition 38 also is that compliance with condition 38 is assured by annual reports once water use commences, and that is to be reviewed by staff. Condition 38, unlike condition 10, does not apply during review for this application for site plan review. This is a reporting requirement similar to reporting requirements like the FMP condition 21. And that condition 38, was not challenged, is final, and may not be relitigated during this proceeding. So the word mitigation is used in two different contexts. With regards to condition 10, it relates to consumptive use under the Deschutes Basin Program and the specific water right for consumptive use. Whereas for condition 38, that relies or relates to the no net loss standard. Two completely different standards and two completely different conditions. So I want to be clear when we're talking about what mitigation means. The only real similarity in between these conditions is that they has correctly been determined that that the mitigation is at the time of water use. So no mitigation is required until actual water use occurs. This makes sense. That's how you provide mitigation to balance the impacts when they occur or when, frankly, water is pumped. So lastly, on the topic of water, I think last thing I want to talk about is that Thornburg has not changed or sought any change with regards to its water use. Although the applicant has submitted various other water right applications for transfers of existing rights, for example, these applications are not being relied upon for this application. This application relies on the OWRD permit that has already been granted to the resort. Although, again, extension has been challenged. These permit approvals or these additional rights are being sought as a backup plan to the challenge permit in the unlikely event that the extension is not, in fact, upheld during Gould's protest of that extension. Nothing precludes a belt and suspenders approach, which is viable and frankly a smart approach, given that the appellant has challenged literally every application, whether it's water use, land use, or otherwise related to this resort. And nothing in these additional water rights constitutes a change in the source of whatever water. And we have submitted expert testimony to that effect, which is Exhibit 19 to the letters that I filed yesterday, and that are already up on Acela. I checked a minute ago. And again, lastly, condition 38, I just want to make one part really clear here. Condition 38 is what ensures compatibility with the FWMP, and Thornburg is still bound to secure the rights from places like the Big Falls Ranch water right certificate. Again, as we talked about in the last proceeding for the tentative plan on remand, this evidence is now in this record. Thornburg has actually closed on a portion of that water right, which is more than enough to comply with the current proposal. But importantly, with condition 38, again, the hearings officer is not authorized nor tasked with monitoring compliance with that condition during review of this development application. That is a staff review of annual reports. That issue has been litigated conclusively and is final. Moving on from water, here again, we're talking about a site plan for OLUs. The issue presented is not whether the issue presented is whether or not the OLUs as proposed are not lock-off units. Lock-off units were authorized in the approval of the CMP and may not be collaterally attacked here. So we meet the requirements of it, and we're not here to relitigate it. And frankly, that would be an impermissible collateral attack on that decision. Appellant Gould has argued that there's a perceived issue with lot of records. And frankly, that's just a perceived issue. The law is not on Ms. Gould's side. No lots were created through a mistaken conveyance that happened. And LUBA has made it clear that a deed alone does not create a new parcel, and that lawfully created parcels maintain or retain their boundaries, even if a deed of a part of that parcel is conveyed without the benefit of required county approvals that created a legal lot. So again, there was an erroneous conveyance, it was rescinded, it did not change the legal lot status, and this is a non-issue. All lots being developed with OLUs under the site plan have already been determined to be a lot of record by the county. And the entire resort property itself was also determined to be a lot of record by the BOCC when it approved the CMP. I think I'm doing real good on time. So the last thing I think I'd say before I want to turn it over to Cameron DeLashmutt is that, again, this decision approves a site plan that complies with the development contemplated by the CMP and the FMP. For site plan review, Appellant Gould and others often attempt to sensationalize the issues as if the sky is falling, the river's going to dry up, frankly, other kind of absurd claims, I want to say. However, as is clear by the amount of significant public involvement and process, the land use process has worked in this instance. The applicant is proceeding to develop the destination resort as was allowed under its previous approvals in the FMP. No deviations from those plans are being proposed, and relitigating those issues that have conclusively been determined would be impermissible collateral attack. Recycled arguments that have been lost at every review body should again be rejected. And so I don't have anything else to say other than we hope that the hearings officer would affirm the approval by staff, and I'm happy to answer any questions that you have.
Thank you, sir. I have no questions at this time. I may at the end of the hearing, but at this point, I'm trying to listen. So this
Can I make?
You may.
Pardon me. One more comment before elevating Mr. DeLashmutt. I would also presume that the record is going to be requested to remain open. And so for what it's worth, while I've got my calendar open and everybody's thinking about this, applicant would agree to a standard 777. The caveat being that the last 7 would end on Thanksgiving Day, which is a closed day, a holiday for the county, as is the 26th. And so the applicant would request that the final legal argument be left open until Tuesday, November 30th, and would be happy to comply with a waiver of the clock to accommodate that record period, assuming it remains open.
Thank you. Long as we're talking about the record remaining open in the hypothetical, because at this point in time, no one's made that request. I would like you to think about, as well as Mr. Delashmuth, on the applicant side, and Ms. Fancher, if she wishes to involve herself. I would prefer, because I think there's an appearance of giving an extra day, and I understand that that may be my own perception and not reality speaking. But I would prefer that the first 7 or the first open record period ends on, rather than the 11th, on the 14th, and then we can simply extend straight through on a Monday kind of routine. And that way, every single period except for the initial open record period, which is the one that I think is most important to the general public. Think about that time frame, if you would. Basically, what I'm proposing is the 14th, 21st, and 28th in alternative to your 11th, 18th, and 26th. And the reason I'm concerned about the 26th is a lot of people, I'm not even sure if the county is open on the 26th. But anyway, that's a suggestion. I'm not imposing it. I'm simply making a suggestion. So you don't have to respond now. Please do so in rebuttal. Mr. Lashmuth, you're up.
All right. Thank you very much, sir. I just want to start briefly with the cabins. So these cabins are the very cabins that were approved by the board in the CMP in 2006 with lockoffs. That was upheld by LUBA again in 2006. And then in 2019, LUBA ruled that the CMP had resolved the issue of cabins with lockoffs. So that is a resolved issue. The one issue that Gould raises here is that we have not provided enough detail in our cabins. And on our cabin detail, outside we show the plants, the pavers, the siding, the trim, and other exterior details. And inside we show the tables, chairs, beds, and other furniture. I'm not quite sure what other detail we would be required to provide. During our last hearing, I had mentioned that this project had some 38 to 39 separate appeals. Since then, there's been another 4 appeals, and we currently have 5 issues pending, 4 of them on appeal, and I imagine the 5th one will be appealed as well. Throughout the appeals, the same issues are raised over and over again. For example, in 2006, Gould claimed that we had made some substantial change that required us to file a new application. The board denied that claim then, and since then she has claimed on an ongoing basis that we've made numerous other substantial changes for a variety of issues, each of which is requiring us to file a new application. And almost every single action that is taken, we see it over and over again, and we see it again here. In 2006, Gould claimed that we needed to provide the contract with Big Falls Water, that we were trying to hide something when we didn't do it. The board denied her claim and LUBA upheld it. She has made and lost that same claim over and over again. And here she says the record will show that we do not now and may never have the BFR water. And that is simply a dishonest statement, and they know it. We provided proof that we had already purchased it. We have provided proof of a memorandum of agreement that is recorded against the property over and over again. On the Fish and Wildlife Plan, Gould argues that we're not meeting the condition and that we need to file a new application. In every instance, it's claimed that we failed to meet the FWMP, the fish plan, let's call it the fish plan, in every proceeding. And the fish plan is final and it's not a part of any further development applications. The Board of Commissioners said compliance with the FWMP is assured by the annual monitoring of the FMP and by condition 38. Luba says the same thing. And the board further said, Luba made clear nothing further is required to comply with the FWMP in order to get development approvals. And as you go through the reasons for the appeal, it's littered with things that are we're not filed, we haven't, we've changed something, we've changed this, we've changed the other thing, we're not providing the mitigation in the right way, we've changed the permit, we've done something different that makes it where we can't meet condition 38 and the fish plan. And those are things that happen with annual monitoring. And we hear over and over again that this is the last chance. Mr. Kleinman would have you believe that Armageddon is going to befall us tomorrow if something drastic is not taken and some action is not taken to stop us. And the fact is, there is this isn't the last chance. The last chance in Mr. Kleinman's and Ms. Gould's perception has been going on for 5 years now. I mean, every single application is a whole new last chance. And the fact of the matter is, we have annual reporting with water resources. We have annual reporting on our mitigation plan through condition 38. And if at any time, I mean, those are all public documents. If at any time anybody thinks that we haven't done what we said that we were going to do, you can bet that there will be a storm raised and we will be called to task to show how we do it. So the whole last chance argument is a fallacy. On condition 10 itself, Gould has argued the interpretation of this condition 10 times. And that started with the Board of County Commissioners in 2006. And then at Luba in Gould 1, she argued that a general condition only requiring compliance with OWRD rules is not sufficient, and that she argued that condition 10 only requires the applicant to comply with water laws administered by OWRD, and that a condition of approval on water quantity does not obviate the need for a condition on water quality. When she made that, she was denied. And so over and over again, we're arguing about the interpretation of condition 10. And finally, last year, the BOCC found the interpretation of condition 10 was resolved by the CMP, and that any further attack is not allowed. It's a collateral attack. The board summarized the ongoing attacks related to condition 10 and condition 38, summarizing together, and said the constant barrage of frivolous claims regarding this issue are barred by the CMP, the FMP, and the FWMP. They should be disregarded and denied outright. And in spite of that, here it is yet again. Gould uses circular argument. She plays the land, she weaponizes land use. As you know, here we are in appeal number 43. She weaponizes land use, and then she uses actions in land use to weaponize water law. She plays one off against the other. She is, and because they're inextricably linked. So the tentative plan is inextricably linked to the golf course, which she failed on that. It's inextricably linked to this. It's inextricably linked to all sorts of things. But then she tries to port her land use laws into water law and vice versa. So the extension of the water rights permit is a prime example of this circular argument. First, Gould uses land use appeals to delay us from getting approvals. And in the proposed final order on the extension, Water Resources recognized those land use appeals delayed issuance of the permit and delayed development under the permit. And when Gould protested the proposed final order, Water Resources still issued the final order approving the extension. She then sued water resources in Marion County and at the Court of Appeals to force them to withdraw the final order. They did it. And then in land use actions, we get this constant argument about condition 10 that we don't have a water rights permit in spite of information from water resources to the converse. And in land use action, she raises and loses issues pertaining to fish and wildlife, transportation, rural lifestyle, and stream flows on the Deschutes River and Wyches Creek. And then she uses those same issues as reasons for the protests of the extension, claiming the extension would impair her interest in preserving the quality of rural lands and fish and wildlife habitat and protecting stream flows in the Deschutes River and Wyches Creek. And so she makes claims in our land use actions that she are litigated over and over again, and she ultimately loses those. She uses those same claims to then make a protest of our permit, extension of our permit. And then when she makes the extension of the permit, she then ports that argument right back into land use and condition 10, this argument about the permit extension. This action right here, right now, is the 11th time that we have battled that. So Gould has lost on that 10 straight times. And here we are on number 11. As I noted, we're at appeal number 43 or so. And that's on 5 actions that we presently have pending. The fifth of which will probably be appealed as well. We have numerous other land use actions that we're preparing right now for other development aspects. And there's little doubt that given the type of weaponization of the land use and water law processes that has taken place historically, that we will see further appeals on those to you, to the board, to LUBA, to the Court of Appeals. And it's doubtful that when the legislature was developing Goal 1 and the public process system, that anyone ever anticipated that one very wealthy, well-funded party would be engaged in 15, 16, 18 years of constant appeals addressed at one party. And that it has continued for so long is hard to call anything other than a abuse of the public process. That's all I have. I thank you for giving me the time.
Thank you, sir. Ms. Brewer, how much time on the applicant side?
They have 2.5 minutes left.
Mr. Katsaroff, anybody else?
No, sir.
You're shaking your head, but I can't hear
No,
you.
sir. Thank you.
All right. This would be the time and the place for anyone in support of the applicant's position, in support of Mr. Katsaroff and Mr. Delaschmidt's testimony. Does anybody raise their hand, would like to testify in support?
We don't see any on the sensor.
All right, then we're at the time and the place where the appellant, Ms. Gould, Mr. Kleinman, Mr. Anuda, I'm not sure who is going to take the lead on this, but whoever it is, please raise your hand first, and then we'll get you going.
I'm assuming Mr. Kleinman. Yep. Producer, would you mind elevating Mr. Kleinman? Thank you. There we go.
And we'll probably get this process down pat right about the time COVID leaves us and we're back meeting in person. But anyway, Jeff Kleinman, 1207 Southwest 6th Avenue, Portland. 97204 for the appellant, Ms. Gould. Mr. Carlanuta, who handles water law issues, will testify as well. So I will try to be brief. Appreciate the opportunity. Good evening, Mr. Frank and Angie, whom I've spoken with at times over the years and never seen. It's nice to meet your upper half. Yeah. So with respect to the open record period that was sort of loosely suggested by the hearings officer, we do request formally that the record be held open. We're going to have different suggestions in this case from the next one that we're going to hear, which is a more convoluted case. But folks have also overlooked that next week has Veterans Day in it. So I think the hearings officer's suggestion that the record be held open to the 14th would be appropriate, although the 14th, I believe, is a Sunday. So it would be the 15th. Is that right?
That's correct.
And
That's
then the
Teach me
20th.
to look at my calendar on the wall.
And I guess the 22nd for rebuttal.
Yes, and I did not take into consideration Veterans Day. I'm not even sure I am a veteran, but I'm not sure what day I'm supposed to be honored.
We'll do it tonight.
So we'll do it tonight. But anyway, I didn't look at that, and so let's keep that open, and you can make your suggestions as you wish.
Okay, so that's my suggestion, the 15th, the 22nd, and what is the Monday after Thanksgiving?
29th.
The 29th for the final rebuttal. So that would be 7 days. 15, 22, and 29.
Okay, that's on the table,
All right.
Mr. Planner.
All right, thank you. So I have not yet filed a separate memorandum in this case, and I'll file a brief one during the open record period. We presented a pretty darn complete statement of reasons for appeal, which I think sets out the issues in pretty good detail. I do want to just make a few points before passing things along to Mr. Anuta. The county's approval of Phase A1, which includes the area encompassed by these OLUs, was approved by the hearings officer on remand from LUBA. We appealed that to the board. The board declined to hear the appeal, and therefore we will be filing an appeal, with all due respect to your decision, Mr. Frank, to LUBA next week. So that is not yet final, and I don't see how OLUs, which are part of a master plan development, can be approved without the tentative plan or plat being finally approved. That should at least be a condition of approval in this instance. So basically, it would be no more than a tentative approval of the OLUs. Otherwise, you would be approving the development on farmland that is not really part of the master, that is not really part of the approved destination resort. This is still farmland. Final master plan condition 1 says that approval is based upon the submitted plan, and any substantial change to the approved plan will require a new application. Approving OLUs outside the scope of the tentative plan would be such a change. There is no impermissible collateral attack in this case, and in the memo we submit during the open record period, we'll discuss the linkage between condition 10 and condition 38, which have been treated separately, but inappropriately so by the applicant. And even though there are reporting requirements required, there must be evidence to support compliance. And as Carl will discuss, there isn't. This is the last point this is the last land use review on the OLUs before construction starts. At the building permit stage, the building official at the county is not going to look at whether water supply has been secured or mitigation has been secured. And hypothetical availability is not the same as availability. These folks could draw water from wells even without a valid permit from OWRD and without doing any mitigation. We filed 2 reports that Carl will touch on from John Lambie, who's a certified water rights examiner, and several other things in the state of Oregon, stating that it is no longer even possible to get the required mitigation water to make up for the loss of anadromous fish habitat. And if that's the case, then this application cannot be approved. That is always a live issue, and there is no improper collateral attack. Of course, the issue that you addressed in the proceeding we just went through on remand from LUBA as to condition 17, as I said, we're appealing that, and assuming that condition 17 ultimately comes back to life, I won't make the assumption, but it certainly could, then that will still need to be complied with, and we can't have a freestanding OLU site plan approved and out there for building permits to issue in that instance. Pardon my shuffling around. So as I said, this is the last point to determine the availability of water for consumption and for mitigation for this particular element of the development, the proposed OLUs, if it's not resolved now. When, and our view is that the whole business about whether it's merely plausible, not impossible, to get water pursuant to permits, that may apply to prior phases that are not the last phase before building permits. But this is the point to really prove it up. And that is a different standard, and it's a standard that needs to be applied here, or you get kind of a wild hair development that's entirely out of compliance with the master plan requirements. I'm going to touch upon just a few of the issues that were raised by Mr. Katsaroff and then hand off to Mr. Anuta. First of all, this, for the reasons that I gave, this site plan is in fact closely integrated with and intrinsically linked with the tentative plan that was approved in the previously appealed decision on phase A1. Golf courses and so-called lakes are one thing, but housing units are quite another. And as I said, these cannot go forward by themselves. When the applicant's representatives talk about an informational standard only, as if that means nothing, they still need to prove up the information, and they keep not doing it, as Carl will explain. As I said, we'll explain the linkage between condition 10 and condition 38 of the final master plan in our next memorandum to you. And finally, I shouldn't respond to the grievances expressed by the applicant, but I just want to assure the hearings officer that my client, both before and during my representation, which goes back 3 years, has acted entirely in good faith and in good faith belief that the applications that have come forward have not complied with the approval criteria. And she's met with pretty good success in that regard. There have been some improvements in the proposed destination resort, but there are now also efforts being made to diminish those, and those are of great concern. So with that, I'll hand off to Mr. Anuda unless you have any questions, Mr. Frank.
No, Mr. Clement, thank you. I appreciate
Thank
your
you.
testimony, Mr.
Thank you.
Anuda.
Let me elevate Mr. Nuda. Thank you. Okay.
Go ahead, sir.
Thank you, hearings officer Frank. So I did submit, but it was after 2 today, a written memoranda with extensive attachments, which is why I was concerned about the 20-page issue earlier, and a lot of them are in color. So I will try now just to briefly touch on the issues, and then you can go through the memorandum and hopefully we'll answer the rest of them. I'll start with a key thing that Mr. Kleinman referenced, which is hypothetically available and is not the same as actual. And that's a huge issue here. As my memo outlines, there's no dispute that the applicant currently holds a permit. The problem is the applicant holds a permit that has expired. It has not been canceled yet, but it is legally expired, and the law is really clear. The applicant can only use the amount of water, can only lawfully use the amount of water that it had put to use before the permit expired. And the documents from the applicant and from Water Resources make it crystal clear that amount right now is 0. They didn't use any water before the permit expired. That's part of why we protested it, because there wasn't a valid effort to put the water to use. Mr. Delashman and Mr. Katsaroff are focused on whether the permit has been canceled. The issue is, can you use water under the permit? And the answer is no, because you never did before the permit expired. That's a fundamental point of water law. In terms of whether what will happen with that permit, we think it's likely that the challenge to the extension that had been proposed but was withdrawn, and I would remind the hearings officer, and it will be seen in my memo, what happened here is that the agency issued an order saying you've got an extension. We challenged it and said you got no basis for that. And then the agency did what agencies almost never do. They withdrew the order because they realized there was a legitimate basis for a challenge, and they actually had a conclusion of law that said we raised significant concerns about whether a proposed extension was approvable. So there is no extension. You have a canceled permit. Then I was a little astonished to hear Mr. Katsaroff say that none of the other permits that the applicant has now applied for, and there are 3 that we know of so far. One was a limited license, one was a temporary transfer, and one is a whole new groundwater permit for more wells. He asserted that those were all just a backup. And I think he sort of maybe got a little out of his skis there. The groundwater permit is indeed proposed in theory as a backup. The other 2 permits do not say anything about being a backup. In fact, the limited license says expressly that it's for construction right now. Fortunately for the resource, the limited license has been denied. The Water Resources has already found that there was not water available within the capacity of the resource for that new proposed use. The same wells are proposed for the temporary transfer, basically, that are in the limited license. Water Resources is, as I've outlined in my memo, going to come to the same conclusion. They're going to say water's not available within the capacity of the resource. They're going to come to the same conclusion on the backup permit as well. So what you really have here is there's no actual water rights available for the use of the resort. They've got applications, but that's it. And they've got an expired permit under which they can't use. Separate from that, you have the issue of the mitigation water, as the memorandums that are very technical, but very detailed and have lots of photographs with circles and arrows, and on the back, if you Alice was restaurant fan, would be the way you describe them, but lots of maps. And they aerial photos and whatnot, they show that there is right now probably no water in Deep Canyon Creek, and there won't be for years to come because of the groundwater pumping that's been going on. And that's not going to change. Mr. Delashman and Mr. Katsarov mentioned that they have closed, I think Mr. Katsarov used the phrase, on some of the Big Falls water. And there is an assignment that shows that they now own part of it. But that's all. They can't use the water. And I've laid out in my memorandum the steps they need to take to be able to use the water in order to get the water to where it has to be for it to constitute or be available for mitigation. And it's a lot of steps, and it's going to take a long time. And until they have that, they're not supposed to start. Now, you heard testimony about how under condition 38, if there's supposed to be an annual reporting, and if there's a problem, we'll be called to task. It's too late for the fish and the river if you wait till that point, and that's not the point of the permits. That wasn't the point of condition 10, and it wasn't the point of condition 38. The point was to say, before you start construction, have water to use in the resort and mitigate for it. So at that point, and they don't have the water. That's the fundamental issue. They don't have the water. And I also thought it was interesting that Mr. Delashman said that Ms. Gould is raising sky is falling issues and the river's going to go dry. Well, that's actually what's already happened in Deep Creek due to the pumping. It's gone dry. So these are not hypothetical issues. These are actual issues on the ground. They're actual legal issues for what the applicant's supposed to provide. I'll leave a little bit of time for Ms. Gould. The one final point I can't resist making, even though as Mr. Clemens says, I should know better. I find it passing strange that Mr. Delashman feels compelled to comment on Ms. Gould's financial condition. He's the one who just got millions of dollars from Sortis, and that's the reason all this is going forward, is because he's got a huge amount of cash. How much money somebody has, whether it's a lot or a little, should be irrelevant to the land use process. Just like how many times an argument is raised, if it's a legitimate argument, you should note, I trust, that every time any application comes up for anything in this case that relates to this resort, for 42 times now, Mr. Delashman and his lawyers have argued everything is a collateral attack. And it's not always a collateral attack. These are legitimate issues. But 42 times they've argued that. Sometimes they've been successful, sometimes not. The point is, you have to look at what the actual law is and what the actual facts, and not be dissuaded by some of these sort of character assassination efforts and long-winded complaints about people exercising their legitimate rights under the law in different forums. And of course, Ms. Gould's interests are the same. They're the same interests that anyone would have if they live near, use the resource. And it doesn't matter that Mr. Delashman actually got a permit in Deschutes County. That doesn't mean that he automatically gets the keys to the kingdom everywhere else. Water law still applies. So do other laws. This is a legitimate issue that we've raised. There is no water available here. And I would ask that you look closely at the materials we've submitted and think hard about what happens if everything here is deemed to be purely informational. And I'd point out, I can't resist that as well. Even if it's informational, hypothetically, they didn't provide all the information to the county. They didn't provide all the information we have. They said nothing to the county about the limited license and how it was denied and why it was denied. They didn't say anything about all these other materials. So even if it was informational, they didn't meet the condition. That's all I'll say. If you've got questions, I'm happy to answer them.
No, Mr. Anuda, I don't have any questions. I should have made the comment after or during Mr. Lashmuth's testimony, but since you followed it up, I am not going to consider, and I find it offensive that we talk about non-relevant issues, and I believe character assassinations are not relevant issues, and I demand of any further testimony that we refrain from attacking somebody's motives or personality or perhaps what they've done in the past. It's not appropriate for you, Mr. Anuda, and it's certainly not appropriate for Mr. Delashma. So anyone else, Mr. Kleiman?
No, we have no one else unless Ms. Gould wants to speak in the few minutes remaining. I would just make one point myself. There was a reference by Mr. Delashma to our client constantly harping on Armageddon. And the fact of the matter is that since this development was first proposed, while there may not be Armageddon in Deschutes County, there have certainly been fires that seem to rise close to that level. And there's been a great deal of desertification. So these water issues have become more and more important over the years. Thank you.
Right. And as a follow-up to Mr. Kleiman's comment, and I mentioned it in my opening comments, I can't make decisions based on personalities or what people's motives are. It's based on the relevant approval criteria. It's based on prior decisions, both of relevant decision-making bodies. And I would appreciate anyone who tends to testify to refrain from any such kind of comments. And Ms. Gould, I apologize for letting Mr. Delashma make those comments, but I also chastise your lawyer for making similar kinds of comments. So let's just stay on the straight and narrow, and let's stick with the issues that are at hand. Ms. Gould, you're recognized.
Hi, thank you. Regarding the 508 site plan on OLUs, one of the things that's really critical is that the pavement and roadways provide for safe passage for those with disabilities. That's something that is important. One of the things that you may know on the application of this development is there is the opportunity to annex lands into this development. And that's a very important reason why specificity for the OLUs needs to be known today and needs to be defined today and not just left kind of willy-nilly to a future time at the workability of the applicant or at a convenience for the applicant. And I noticed also in the accounting based on the amount of mitigation dollars that would be paid, it was based on an acreage. And again, with the ability of this resort to annex in lands, it's important that if there is a price per acre for the mitigation to be paid, that is defined. And that's another reason why these site plans are so critical, that they remain defined and not just put out there into a future trust us, we'll do it later scenario. On the decision, I found it quite interesting that the site was described as 1,980 acres. It's not 1,980 acres that's approved. It's 1,970 acres. And so it's important that we keep these documentations relevant. And the annual report that the applicant claims is something that staff reviews. It's an annual report that's due from the Department of Fish and Wildlife and the Bureau of Land Management. And so that links both condition 10 and condition 38. And irregardless of if anything was done on mitigation, the annual report is still required. So I'm not sure that that annual report has been received. The other thing I'd just like to add is the BLM, who's a partner under staff to be reviewing the annual report, wasn't included in the land use notice by the county when this application went out to agency comment. So hearings officer Frank, over these various years, the issue is this is a very cumbersome resort and the onus is on Deschutes County to be reining it in. And there has been a continual shifting since the very beginning, since '05, of what the promise was and then what the deliverable was. And again, on this, on the tentative plan, the county would have loved to have continued without paving roads for the American with disabilities. And that's not acceptable on a public destination resort. And so in thinking about the public coming to rent these OLUs, it shouldn't be put into the future as what their setbacks are or what specific named roadway approves it. There needs to be ADA parking for the OLUs. There needs to be parking for the staff who are working the OLUs, et cetera, et cetera. And I will just defer to future written comments. And I thank you. I appreciate the newest planner to this task. It's pretty daunting, Angie. I did hear your interview on KZ21. And this resort is unlike any other here in Deschutes County. It's remote, it's rural. We do not have the rural infrastructure in place. And the other thing I might add, this is a very large resort and it's been a shifting sandy wind since its inception. And it's not the public's job to be steering how it's done. And frankly, it's not Deschutes County's job to be developing or applying for this. So one question I have is this application deemed complete today on which we're able to comment? Or will we still see in the open record period yet more information to substantiate what they're trying to do on this application, the 508? And then finally, with the BLM not being informed, I think it is relevant that the right-of-way that's being used as a construction entrance is supposed to have a cattle guard at the very easterly end. That is not in place. This construction road across BLM is actually using more BLM land that the right-of-way had not identified. And finally, I don't know where the water is that they're watering down the construction they're doing on the site. So perhaps the Katsaroff and Fancher and the Lashmet team or the Newman team could explain the water that they're using for dust control and for road building, where that is coming from today. Thank you.
Thank you, ma'am. Appreciate your testimony. Anything else, Mr. Kleinman? I don't know, where do we stand? Where do we stand on time, Ms. Brewer?
We have about 5 minutes, and I just want to make it clear on the record that we did not count time where there was discussion about the open record period for either party. So just in case anybody else was running their clocks at the same time, that makes up the difference.
Yeah,
Thank
I
you.
think we can, thank you. I think we can move this along. And
Okay.
so that wraps up for us.
Thank you, Mr. Kleiman. This will be the time and place for anyone that is neutral. This is a group of folks that I seldom see.
Nobody raising their hand at this time.
That doesn't surprise me. This would be the time and the place then for anyone in opposition. And I'm sure there's a few of you out there, so if you wish to testify, please raise your hand and you'll be recognized. Maybe not immediately, because someone else may be recognized first.
Rima Gibbet.
Rima Givet has her hand raised,
And she's been elevated as a panelist.
and she's been elevated, although I see Carol Macbeth has been elevated as well.
It looks like all people wishing to testify.
Oh, interesting. I apologize, everyone. My screen does not show everything that I anticipated it would show. So the first name was Rima. If you are there, Rima, please feel free to start your testimony.
Thank you. Good evening. Can you hear me okay?
Yes, I can hear you just fine. Would you please give us your address, please? And spell your last name just to make sure that I've got it right. In fact, I'm not even sure I've seen the word Remus, or the name Remus. So if you could spell both your first and last name, I very much appreciate it.
No problem. My first name, R-I-M-A, Rima. My last name, Givet, G as in George, I, V as in Victor, O-T.
Thank you, ma'am. And your address?
18557 McSwain Drive, Sisters 97759.
Your testimony is, I'm looking forward to hearing your testimony.
I really appreciate the time. My concern, I want to reiterate concern about available water. I'm aware that there is some surface water from the Deschutes through Big Falls Ranch. I am concerned about how that water would get over to Thornburg Resort. And I believe we are in a similar aquifer as Thornburg Resort. I understand that there is some concern about that groundwater being connected to Alder Springs. And I am very concerned about having mitigation of water from the surface taking the place, or being the mitigation for taking groundwater. And we are at a time right now in Deschutes County where anecdotally different well drillers have told me and family that they're seeing up to 3 wells go dry a week this summer and into the fall. And so drilling more wells for Thornburg is a huge concern of mine. And I think more information needs to happen before actual drilling happens for water. That's my concern. Thank you so much.
Thank you, ma'am. Appreciate your testimony. Who's next?
Carol Macbeth.
Ms.
Good
Macbeth.
evening, Hearings Officer. Thank you for the opportunity to testify on behalf of Central Oregon Land Watch, where I'm a staff attorney. Our address in Bend is 2843 Northwest Lolo Drive, zip code 97703. Our comments apply to both applications. We've submitted written comments into the record for both. I regret that a prior commitment will keep me from verbally testifying this evening in the second hearing, but our comments apply to both. We recommend denial of both applications. The uses proposed are for tax lots 7,800 and 7,900 in the north 1/2 of the southeast 1/4 of section 29, township 15 south, range 12 east of the Willamette Meridian. And to prevent fragmentation of its agricultural land base, the county only allows development of exclusive farm use parcels based on when and how those parcels were created. Since 1977, Deschutes County has not allowed parcels to be created by deed. Rather, they must be created by either subdivision or partitions approved by the county. So neither tax lot 7800 nor tax lot 7900 qualify as lots of records, and neither may be developed under the county's code. And we provided the specific code sections in our written comments. These are brand new parcels. They were created by deed on August 31st, 2021. The applicant, Central Land and Cattle, conveyed 0.5 acres from the middle of 7800 and 7900 between those two. And we've provided a map in our written comments. On July 30th of this year, the July 30th deed created three new parcels, the little 0.5 acre parcel between them. It created a new parcel of the land previously called TL 7800, which it's still called, but it's a different parcel. And then 7900 also reconfigured into a new parcel on July 30th of this year. Then somewhat hurriedly, Pinnacle, who was the transferee, transferred the 0.5 acres back. This, however, did not validate the new parcels. The new parcels were created by deed at a time when that is unlawful. That is the present time. Ever since 1977, it has been unlawful to create parcels in this manner. It was unlawful on August 30th when these parcels were created. They can't be developed. It's not a matter of the law of the case. The law of the case does not apply, as the Supreme Court of Oregon has explained, when there's been a material change in facts. There's been a material change in facts in the area of land that these parcels occupy has now changed twice. The applicants say that there have been prior lot of record approvals. Those are just for the same names for the prior parcels on this area. The new parcels from August 30th retrace the boundaries of the old ones. They overlie those. But the regulations that prevent fragmentation of the agricultural land base are about the time and manner in which they were created. And the time was this summer, and the manner was by deed. It was unlawfully created at an unlawful time for creating parcels by deed. And that's why they're not lots of record, and they cannot be approved for development. They may continue to be used for farmland, but they can't be used for a destination resort or any other developed use. And if you have any questions, I'd be happy to answer them.
No, ma'am, I appreciate your testimony, and I will review your written materials.
Thank you.
Carolyn Wise.
Anyone else wishing to testify in support of the appellant's position or the opposition?
Mr. Hearings Officer, we have Carolyn Wise with her hand up.
Yes, can you hear me? Oh, let's see, hang on.
Yes.
Oh, okay, I think I'll start. Oh, there I am. So I'm Carolyn Wise. I live at 289 Southwest 59th Street. And I've been a resident here for 16 years, and I'm voicing similar concerns as to the first person who spoke. Is also about water. The ranch where I live, they've already had to drill down further to get to water. And so I know it's an issue, and it still feels like water pressure is low. They're probably going to have to dig down again to go deeper. The other thing too is that the traffic, I feel like I risk my life every time I leave my drive. The infrastructure, I think, is very poor. There's been accidents on this road. There have been deaths. With more people coming in, I think it's going to be a death trap on Highway 126. And Klein Falls Highway, I think, is going to be really bad as well. So, and the other thing too, I think for the water usage as well, it just doesn't take much to just look around and see the reservoirs, and they're dry. In Madras, like, the farmers aren't getting enough water to grow food. So most everybody I've spoken to in the community has said it's absurd that they're going to want to build 3 golf courses when we're already suffering with water, lack of water and drought, and the fires as well. So anyway, thank you for listening. And that's about all I have to say for now.
Thank you, Ms. Wise. I appreciate your testimony.
You're very welcome.
Christine Larson.
Go ahead, ma'am.
You're muted, Christine.
Okay, there I go. There were several things that I wanted to say, but just listening to this hearing, and this, I probably should have brought this up at the beginning. I feel a lot of this is very disparate and is being directed at people who are highly educated and knowledgeable in these matters. So I really don't know how fair these hearings are. We still have a lot of people in Eagle Crest and in the area that don't know about Thornburg. And I know many of you will think that's funny, but they don't. I am not an idiot. And I'm listening to this. And after doing the reading that I've done and listening, I really am not sure what I can object to, what I can talk about, and what is efficient dialogue here. When you're throwing away around HB this and that and everything else, the normal person does not have a clue what you're talking about. The people that are just finding out about Thornburg right now, everybody's concerned about the water. I heard Delmashot talking about, you know, all the things that they did for water, and even somebody mentioned that it's being ridiculous that we're running out of water. Is water the subject we're talking about? Is the next hearing adding more dwelling units? My property at 20200 Marsh Road, we have not been able to cut off a piece of land, deed it, and then get it back. How does that happen to somebody who is so knowledgeable at land use and is attempting to build 3,000 homes? And I believe it must be the next hearing where they're going to ask for 20.25% more dwelling units. I'm sorry, I am totally lost in this hearing. Most people on the street are going to be totally lost in this hearing. And I really, really wish that Deschutes County, Eagle Crest, and other parties involved would get the word out more than 750 feet from where the improvement's going, and have discussions in a readable and talkable manner to us people that are on the street, to the farmers that are so concerned about losing their water, which I am one. We can water every other day. We can't transfer our water rights willy-nilly. It seems like a lot of us have more regulations than Thornburg does on a plan that was pretty much approved in 2005, when things have changed quite a bit. And instead of trying to be a good neighbor, they are asking for more and more and more. And I certainly did take offense at what was said about Mrs. Gold. So anyway, that's it for my input right now. I'm not going to be able to make the second meeting, unfortunately, but I certainly look forward to finding out at the next hearing specifically what can be addressed and how I can explain it to my very many neighbors who have no idea what is being talked about. Thank you.
Thank you, Ms. Larson. I appreciate your testimony. I feel bad that you feel the way you do. It's a process that sometimes doesn't seem incredibly friendly to those who are not involved in it a lot. I strongly suggest that you and anyone else that's interested make direct contact with the planner and talk as long as you need about what the planners do and the laws that they look at. But I appreciate very much your testimony. Thank you. Who's next?
Jerry Cullen. Him out there still?
Muted.
Oh,
All
Mr.
right,
Cullen,
can you hear
muted.
me now?
Oh, there you are.
Hi. Thanks for letting us speak. And please, Greg, do read Miss Macbeth's information that she's going to submit. And I do agree with all the other folks that have been in opposition and support the views. I live at 1015 Northeast Henderson Drive in Madras. And I hike around the Klein recreational area and getting to Klein Butte, it starts on, as they were saying, they're using the right of way through
I'm sorry, I've lost Miss Collin.
Yes.
I'm
Can you
sorry,
hear
I
me
couldn't
now?
hear what you said. I can.
Oh, can you hear me now?
Yes, I can.
Okay, so I was not able to hike to Klein Butte because of the construction. And they are using BLM land access to get to their construction site. So, I'm very concerned about the water, but it's just one other thing that it's supposed to be the Klein recreational area there. And they are obstructing access to Klein Butte. So I just wanted that to go on the record, and please read Ms. Macbeth's information and listen about the water. It is very tragic. And we don't need another golf course. The amount of water that they take is incredible. But thank you.
Thank you. Appreciate your testimony, and I assure you that I will read Ms. Macbeth's submission. Okay, next.
David Arnold, please.
Good evening. My name's Dave Arnold. I live at 19830 Canarn Road. That's CONNARN here in Tumalo. I've been attending these meetings probably since the beginning of the Thornburg thing, and I have to agree with Mr. Menuda on the water issues that he brought up. I myself have done the similar research, just being a landowner and a farmer here in Tumalo, and found that the Thornburg did have a license. The license was appealed, and a final order was written on July 20th, 2018, that sent the withdrawal of his application to extend to a hearings officer for contested case hearing. I didn't know what that meant. I talked with Jeremy Griffin and the water master here in Deschutes County and asked him, what does the contested case hearing mean? And he told me that that goes before a board of OWRD. They review the information provided by folks, and they make the decision on whether to extend the license or to cancel a license. But what was interesting is what he said at the end of our conversation. He may have a license, he has an application and he has a permit, but he's not allowed to pump any water until such time as a contested case hearing is heard. Now, Mr. DeLashmit's attorney says they can pump water now. So I'm not sure who's right, who's wrong. I have to believe OWRD because they're the ones that control the water here in Deschutes County. I didn't, and I will read or go through Mr. Anuda's submittals later today or tonight and make submittals of my own. But basically what I've done is researched OWRD, Deschutes County records, and put together a list of applications by Thornburg as to what's going on. And therefore, I will not burden you with duplicate information. Now, in the case of Mrs. Macbeth and her talk about the land, again, I also did some research on the land. I did see the sale of the 0.5 acres. I was not quite as extensive in my research as Landwatch was, but I did see the sale of 0.5 acres and of a 10.7 acre sale also from Central Land and Cattle Company to Pinnacle Utilities. I questioned that through Landwatch when I saw it. A couple of months later, I saw that Pinnacle Utilities in the Deschutes County records sold that 0.5 acres back to Central Land and Cattle Company. But then I noticed that the 10 acres was actually renewed in the county records by a title company. I then went on Dial to look up, okay, so what's going on with this 10 acres? And it actually turned out that they showed tax lot 7801, which is part of the 1,980 or 70 acres of the Thornburg Resort, has been sold to Pinnacle Utilities. Well, I remember in all our processes here that until the OLUs, the 50 OLUs were built, Pinnacle, or not Pinnacle, Central Land and Cattle Company could not sell any land. So I question, why is Central Land and Cattle Company selling 40 acres to Pinnacle when they're not supposed to be? Because otherwise, why aren't they selling it to Joe Blow down the road? And my last, and I'll read Mrs. Macbeth's submittal as well and add what I have found above and beyond that. In regards to the earlier testimony given about records, where they're going to be held, what's going to happen, I had the opportunity to submit an appeal to a record at Deschutes County. I put together my information, wrote my letter, put my attachments in, and sent it to the current hearings officer. She came back with a letter to me that said, sorry, you need to go to LUBA, you need to consult your attorney. And I've never seen that before. I'm a guy that lives on 10 acres in Tumalo, been here since 1973. Since when do I have to go to an attorney to point my views when other people have already pointed views into that? I get a letter back, a second letter back that tells me all these county codes that I must follow. I'm a little confused as to what's going on in the county right now, and I will submit again, and hopefully I will not be turned back because of some misunderstanding, because I've done nothing different this week than what I did 5 years ago, 6 years ago. So again, thank you for letting me testify at this point in time.
It's exactly 5 minutes.
Good job. Anyone else?
Yes, there is, and I'm sorry, I'm seeing John
G, we just have an initial.
John G has his hand up. And it's the letter G, an initial. There he
Hi,
is.
my name is John Gibbett, and I live at 18190 Winona Road, off of Holmes Road, out towards Sisters.
Could you spell your name, sir?
Gibbett, G-I-V-O-T.
Oh, okay. I thought you said Garrett and that just, I'm sorry. Go ahead.
So my concern is also about water use. We had to deepen our well this summer at quite an expense, and we've had 2 or 3 other neighbors who have also had to deepen their wells in the area. So concerned about that. I've heard that golf courses require a very large amount of water. And I'm curious what who regulates their use. I've heard other local golf courses taking water that they're not allowed, and nobody's regulating that. And so just wanted to voice those concerns. I also question whether it's realistically, it's like all the landowners that are having to deepen their wells are effectively subsidizing the golf course if they're taking water, if they're lowering the ground table significantly to the point that people's wells are going dry. So is that something that we want to support, and who's effectively paying for all that water that's being used if it's being pulled out of wells and lowering the ground table or the water table? So that's all I had to say.
Thank you, Mr. Gibbett. Just as a reminder, the hearing we're talking about tonight, and I'm not trying to be disrespectful to you, Mr. Gibbett, because your issue is water, but this is not about the golf course. It's about overnight living units and a site plan. Anyone else to testify?
Yeah, and so can I add one more thing to that?
Sure.
So how much water will that development require? And is it the same issues? Is everybody else who has to deepen their well in the area subsidizing your water effectively, or subsidizing the water for the development?
Your point's well taken. Thank you, sir. Ms. Burr?
Paula Latassa?
Hi, thank you, buddy. So I would like to just try and keep things on track here and acknowledge and appreciate the testimonies of Carl Anuta, Nunzi Gold, Rima Givet, Carol Macbeth, Carolyn Weiss, and I particularly want to just say thank you, Carolyn, for your brevity. That was incredible for you to so articulately explain the complications of trying to navigate the process and how we need to make this more accessible to everybody, because everybody is feeling these issues, and regardless of what we want to minimize it to. And I also want to say that I agree with David Arnold's testimony in particular, and in that regard, say how many people, I'm a 30-year resident of Central Oregon, and I cannot count how many people I know that are experiencing the same issues expressed by David, Rima, and John about having wells that have gone dry, having to go deeper. These are people that have lived here for a long time. We do not need to subsidize the new people's water rights for golf courses and destination resorts that don't belong here. We have limited water rights. And I, with all due respect, hearings officer, I do say that. I just want to say how important it is that we cannot dismiss, as did Mr. Dalchemont, and I apologize for butchering your name, and now I'm getting emotional, but we're talking about water for food, for farms, for people that live here, not for people that want to come on vacation. And I do also want to say, contradictorily, as a person and a property owner of somebody who has property in Wasco County that is reliant on the flows of the Deschutes River based on the allocation rights of what we've given today. These, I find it so disrespectful how our water, which is based on antiquated water rights from the 1870s, how it was alluded to that Nunzi is using this to hold the applicant of Thornburg hostage. No, this is why these rights exist. And hearings officer, you need to respect that. This is not about somebody's willy-nilly right of, oh yeah, I'm gonna hold you hostage to the law. No, we're holding you accountable. Done. I'm done. It is accountability, not holding somebody hostage, not going for a collateral attack. Be accountable to what our natural resource limits are. That is the future. Hearings officer Greg, please listen to the reality of what our future holds. Thank you so much. I'm done.
Ms. Latassa, I appreciate your testimony. Anyone else?
Susan Strauss, she's still on the line.
Yeah, hi, hello. I have nothing more to add. I'm just, except for one thing. I just want to say that I have to say supports what Nunzi Gold has brought forth for us. I'm deeply appreciative of Paula and Carolyn and Christina's comments, because as I'm also a 30-year resident and I live about maybe a mile away from where this this destination resort is proposed. And this year, my husband and I are very close to retirement. And this year, we had to suffer almost every other week for fear that the water that we were getting for irrigation, which was cut in half. So we paid the same amount for our irrigation water, which is not cheap. And we had half of that all summer. So, and you know how miserably hot it was this summer. So we had to rig special things to keep our crop, which is our retirement work, watered. And then we're praying constantly for just a drop of rain, which we never got any of. And so it was just a huge struggle. So again, as also John had mentioned, we kept saying, oh, great, we are the ones who are going to be subsidizing Thornburg's golf resort. I just want to say one last thing. I do know that the USGS did a survey, gosh, must have been 20 years ago, that showed that the groundwater levels in Deschutes County were going down. And friends of mine who worked in resource agencies had said that that would surely be an end to future golf courses. I do understand that golf courses take a huge amount of water, and a newly moved in neighbor is a retired hydrologist. And he was horrified to hear about 3 golf courses, let alone 3 lakes. And then to read on Thornburg's Facebook site that someone who thinks they might live there is wondering if they can all have swimming pools as well. I mean, we who have been here 30, 40 years and are using our water resources to make part of our living, we can be put out of, we're gonna have to sell our property and move someplace else at retirement. And that's it. That's all I have to say.
Thank you very much.
Maybe you want my, okay.
Mr. Hearings Officer, I don't have anyone else signed up for testimony.
Right, before we move on, I just want to make sure, is there anybody in the audience that would be considered in opposition or in support of the appellant's position who wishes to testify that hasn't said so as of this point in time?
Anyone raising their hands? Nope, nobody has raised their hands.
All right, Ms. Brewer, I'll give you a chance if you'd like to speak now. I will give you an opportunity to speak later if you so desire. But do you have anything that you'd like to add at this point?
No, nothing to add at this point.
All right, this would be the opportunity for the applicant to present their rebuttal. As I indicated earlier, I will be giving the appellant an opportunity for rebuttal. We didn't talk about time frames, but the record is going to remain open. I make this promise each and every hearing that anything that's submitted in writing, I will read. And I understand that it's not late yet, but it will be getting later after the second hearing. So if you can be respectful, I'd appreciate it. Mr. Katzeroff?
He's being elevated. Thank you.
Sorry, can you hear me?
We can.
I will be very, very brief. I think that Mr. DeLashman has one thing that he may want to say as well. So if you could elevate him while I'm speaking, hopefully we can make this real quick. The first thing I would say is that we're not proposing a new destination resort. We're developing in compliance with an FMP. It's not in isolation. This isn't isolated overnight lodging units or anything of that nature. In fact, we've got an approved golf course to begin with, among other land use decisions that are in various stages of approvals. Importantly, as part of that golf course decision, for example, the roads have been approved. And so this isn't a freestanding development. This is something that's already been approved, and we are complying with continued development under the FMP. We'll, I think, with the exception of what Mr. Lashman wants to chat about, discuss water more as a written perspective. I would just say this: we have a fundamental disagreement with the appellant in terms of the status of the water right, the ability to pump, et cetera. And so I'll just leave it there and say we'll be responding more in rebuttal, as well as the fact that we have submitted additional evidence yesterday on exactly this question, I believe. And so with that, I'll turn it to, sorry, my dog keeps poking up. We'll turn it to Mr. DeLashman real quickly, and then we'll, I assume, chat about the record.
how times have changed with these hearings. Mr. Delashman.
Yes, sir. So my testimony was not intended as any form of a character assassination. I felt that I was giving a factual repertoire of what has happened and what has continued to happen from my perspective. So for any offense, I am sorry. I am sorry for the comments. Mr. Anuta said agencies never withdraw a permit. Right now, Oregon Water Resources has 130 contested cases. They have had a terrible problem with not enough legal resources to be able to fund those, and there is all sorts of people that aren't getting their contested cases heard in a timely basis because of that. When they get filed multiple lawsuits, they tend to withdraw orders. A similar thing happened with the Water Management Conservation Plan. There was lawsuits that were filed on our final order of the Water Management Conservation Plan in Marion County, and they withdrew that order, or they asked us if we would voluntarily withdraw that, which we did. Christine Larson was concerned about 3,000 homes. I could understand how that would be a concern. We're permitted for 950 single family homes, not 3,000. Jerry Colon was concerned about obstructing access to Klein Buttes, and I can fully sympathize with that. We're not really obstructing access to Klein Buttes. There's another way around to get up to the top of Klein Buttes. What has happened, and people don't understand it, is they have been coming across private property for years and made a habit of doing that, and we have since fenced that off for safety purposes. Yeah, I think that's, Mr. Anuta also was discussing the limited license and that Water Resources found that there was water not available. And I will read from the groundwater availability or groundwater review, which is section B of the groundwater review, that says, based upon available data, and this is a hydrogeologist by the name of Michael Toma, who's a groundwater specialist for the Deschutes Basin. I have determined that groundwater for the proposed use will likely be available in the amounts requested without injury to prior water rights. So what Mr. Anuta, what he was claiming, it is a different part of a code that doesn't deal with the individual applications, but the code that I was just quoting from deals with specific groundwater applications. So those are the only comments that I had. I appreciate you allowing me to put those in.
Thank you, sir. Anything else, Mr. Castro?
No, sir. Thank you.
All right, this will be the time and the place. Mr. Kleinman, Mr. Anuta, Ms. Gould, I'm not sure who wants to take the lead. I'd appreciate it if you'd have the same brevity or similar brevity to that shown by the applicant.
Muted.
Jeff, you're muted.
Jeff Kleinman from Ms. Gould. I'll be exceedingly brief, just in response to rebuttal comment by Mr. Katsaroff. We understand that this resort is subject to a final master plan, and our effort is to assure compliance with it, which has not been demonstrated. With that, I'll hand off to Carl.
Mr. Anuta?
Thank you. I will be equally brief. I wanted to respond simply to that last comment by Mr. Flashman. I put the groundwater review and the denial of the limited license into evidence as part of my written submittal, so you'll be entitled to see the entire thing. The part that Mr. Delashman did not read is the part where the same hydrologist checked the box that said, will there or will there not be likely be water available within the capacity of the groundwater resource? And the box checked is will not be available within capacity. That same hydrologist also notes that there is a long-term decline trend in the aquifer in that area. And ultimately, that's why the department concluded that, and I'm quoting again, groundwater for the proposed use is either over appropriated, will not likely be available in the amount requested without injury to prior water rights, or will not likely be available within the capacity of the groundwater resource. So I respectfully disagree with Mr. Lashman's theory that it was actually available and it was denied for some other reason. You'll also see that fundamentally the problem here is there isn't water available, and the department concluded that this new proposed use of the limited license would interfere with state scenic waterway flows, which have priority for the Deschutes. So that's why they denied it. But you'll see that in the materials because I've submitted them, and we'll submit some more materials, I suspect, once we see the materials submitted by Mr. Katsarov, because it sounds like he and I do indeed have an interesting disagreement on whether or not they can legally pump right now. So I'll be intrigued to read his materials and respond. Thank you.
Thank you, Mr. Onuda. Mr. Katsarov, final word.
Okay, he's being brought back over. Just one moment.
Sorry, I was demoted. No, I think we're good. I would love to discuss the record at this time if the hearings officer is prepared for that.
That is fair. You heard Mr. Kleinman's recommendation. You heard that I was looking at a calendar which is right next to me on my wall, and I was looking at Sundays. I apologize for that. But my reference, I think, was Mondays. I just got the dates wrong. So do you have any problems with the open record period being the 15th, 22nd, and 29th? I think that's what Mr. Kleinman suggested.
I think we would prefer keeping it to the 12th and 19th, and then the 26th. If the hearings officer wants to go further than that, I mean, we would prefer to keep things short. As staff knows, there's a lot going on right now, and the quicker we can get this proceeding done, the quicker everybody, including Ms. Gould and her team, can work on other Thornburg related files as well. And so we would propose, I think, the 12th and 19th, and again, we would ask that the final legal argument, given that it's Thanksgiving, is extended for a couple of extra days, and we'll provide the clock. I'll make one argument on that basis, which is that the statute, we think it's fair, first of all, given that we've got the Thanksgiving holiday, which is one of the most traveled days of the year, but also ORS 197.763 6B says that final legal argument will be left open for at least 7 days. And so given that we're asking for a couple of days, one of which is a national holiday where the county is also closed, that's just kind of our perspective.
Mr. Hearings Officer?
Mr. Kleinman, just hold off for a second. Ms. Brewer, any comments regarding the final 150-day clock?
I believe, and I'm looking to Will Groves here in the room with me, that February, I think the timelines were told so that February I can pull that really quickly.
I can open the decision, but
February 12th, 2022 was the 150-day clock after the original tolling. I'm looking to Will for confirmation on anything I might be missing.
So the county's only interest here, we share the hearings officer concern about a general notion that, that there's a fairness to the parties. And we see the hearings officer's notion there of extending it in the way initially proposed. And in the same way, we also see Mr. Katzeroff's argument as valid, that, that a certain number of extra days is appropriate there. Our primary concern is with keeping an eye on the 150-day clock. And so any extensions that it will be provided by the applicant is fine by us. If Mr. Katzeroff wanted 14 days, it would be of no concern with us with regard to the record, because the clock would be extended by that amount by the function of the county code. So we have no special interest in holding this thing shorter. And that's all. Thank you.
Mr. Katzeroff, let's assume that I take Mr. Kleinman's suggestion, since you're citing statute. Certainly a portion of the statute talks about what counts against the 150-day clock and what doesn't. My recollection is the argument period does not, under any circumstances, but unless requested by, in fact, I think this is relatively consistent with the Deschutes County Code, which is just a little different. But what I'm getting at sort of obliquely is that you're willing to extend the record for the 12th, 19th period. And that's really the concern that I have, that's 14 days. So are you willing, even if I go to the Monday versions, to still extend the clock for those 14 days?
I would need to get confirmation from my client. So I don't think there's a
If
confidential.
you want to talk to your client real quick, that's fine. What I'm trying not to do, I'm trying to balance
Understood.
a number of interests here.
Understood. If we can elevate Cameron Delashmet, I'm just going to let him opine on it. I don't think there's a confidential communication that needs to occur between us at this point, unless he tells me otherwise.
Okay, go ahead.
Let me be clear. I don't understand exactly what you're asking.
What I don't want to do, and I feel somewhat placed at a disadvantage here a little bit, is that I don't want to lose the 14 days, which extends the clock. And so what I have proposed, or at least Mr. Kleinman's proposed, and I think it makes sense, is that we extend it by, I'm not sure how many days, but I think it'd be 5 or 6 days is really what it amounts to, because we're counting the weekend and the Monday.
So let me ask this question maybe a little bit differently. So under Mr. Kleinman's proposal, the record closure of the open record period would occur on the 15th and then on the 22nd.
And the 29th.
Assuming final legal argument.
Yeah, you end up with the same argument date, but it's 7 and 7 and 7, and it's equal for all of those periods of time. And I understand it's somewhat arbitrary and capricious that I'm asking for this, but it seems to make sense and seems fair to me. But I'm not going to be put into a box, and that's where you hold a little bit of the trump card here, is that I don't want to lose the 14 days added on to the clock.
Well, and why don't you want to do 12, 19, and 12, 19, and what did you suggest, Ken? 12, 19, and 29. And why don't you want to do that, sir?
Because I wanted to make each open period the same.
The only comment I would have on that again is, you know, we're trying to get our final legal argument done during one of the busiest travel days of the year, where people go see family for Thanksgiving. It's an actual, you know, generally celebrated holiday. And so although the day periods are the same, the holiday is a different consideration in this particular instance, I would say. I don't think any particular issue has been raised so far in this proceeding that is that different than what was litigated in the tentative plan remand, for example. And so I'm not sure that adding additional days for the open record period, moving it instead of the 11th, which would be typical, down to the 15th, is really that warranted. And in that perspective, the open record period there is then longer than 7 days, whereas the final legal argument period doesn't have the same amount of days. And so if you have a concern for it being fair, the open record period is not as long as the final legal argument then. And so that's one concern that I have. And if we want to do 8 day, for example, that would be the 12th and roll over to the 22nd. But I'm just trying to work around a pretty tight schedule for everybody here.
May I be heard?
Go ahead, Mr. Kleiman.
Yeah, it just doesn't make sense to me that the time for final legal argument would be longer than the time for parties to submit evidence and, you know, perhaps more importantly, rebut evidence. And it seems like an unreasonable squeeze for no good reason to shorten those times and allow more time for just their final legal argument.
Okay, I asked Mr. Katzeroff a question and it was deferred to Mr. DeLash. But if I go with Mr. Kleinman's suggestion, am I going to lose the 14 days?
If I might jump in here, the normal schedule here would be, we normally go to the following Thursday. So normally we would go 11, 18, and 25 by default. You know, if this were on Tuesdays, we go to the cascading Tuesdays. So in this case, we're already looking to go to a kind of the next Friday, the 12th, 19th, and the 26th. By function of the county code, anything that's due on a holiday automatically rolls over to 5 p.m. on the 29th. So if we were to put this in if we were going to put this in a strict 7, 7, and 7 schedule in the way that we normally would, we go 11, 18, 25. And because the county is closed on the 25th and 26th, that would roll to the 29th. So that would be the off-the-shelf answer that we would normally use. You know, if there's a preference for the Fridays to add it and go 12, 19, 26, it has the same effect of rolling to the 29th. And I think that gets to Mr. Katzeroff's point, is that he would be unable to hand in materials on the 25th or the 26th. It necessarily rolls to the 29th.
When does the county recognize Veterans Day?
We are off on the 11th. So I think that's why we bumped it to the 12th, 19th, and 26th.
Exactly.
Okay. I am persuaded by Mr. Groves and Mr. Katzeroff on this. We're going to go to the 12th, 19th, and 29th. That was okay. Well, I better write that down or I'll never get that straight. All right. I believe that time period will meet the statutory and the code deadlines. So for those of you who are in the audience, and particularly Ms. Larson, who is, I've probably confused the living dickens out of because she wasn't overly familiar with the land use process, and I apologize. I just want everyone to understand that decisions are due. A final decision is due under the state statute within 150 days of the application being deemed complete. And so with that in mind, all decisions, if my decision dissatisfies anyone, and in this particular case, I'm probably guaranteed of 50% of the folk, or 50% being unhappy with whatever I do. Maybe not in raw numbers, but both sides are not going to be in likelihood happy. So somebody is probably going to ask the county commission, hear this, if they do decide to hear this, I want to give them ample time to make a decision. So the open record for new evidence, is going to be until 5 p.m. And Ms. Brewer is going to talk about this until November 12th. So November 12th will be the new evidence. November 19th will be rebuttal evidence, and I'm going to talk about this in just a sec. And November 29th will be final rebuttal or final argument on behalf of the applicant. All right, so if you have your calendars out, everyone, whether they're listening, whether you tell them about it, anyone has the right to submit new evidence until November 12th. And Ms. Brewer, that's 5 o'clock, correct? And you'll explain it? Correct.
Yep, I will.
Yes, so you have until 5 o'clock on November 12th to submit new evidence. You have until 5 o'clock on November 19th to submit rebuttal evidence. And let me explain what that means. Rebuttal evidence is responding to what came in that first week. It's not absolutely new stuff. It is in response to what came in during that first week. So 5 o'clock on the 19th is the deadline for rebuttal evidence. Only the applicant has until the 29th. Only the applicant has until the 29th at 5 o'clock to submit a final rebuttal, final argument. Going backwards, final argument, as Mr. Katzroff, I'm sure you know, but I bring it up in every single hearing. The statute you were quoting from, almost the same section of that statute defines what argument is. And what it isn't is new evidence. And I am very much an ogre, very strict. If I see new evidence, my historical practices was I simply put whatever that document was in an envelope and don't even consider it because it's got new evidence. I don't believe I have authority to do that, but it's a great threat. So I fully expect that you are not going to be offering any new evidence during the period from the 19th to the 29th. So for all of you in the audience, until the 19th, you can submit whatever you want. I appreciate it, would greatly appreciate it if it related to relevant approval criteria. That would really be helpful and appreciated. Until between the 9th or the 12th and 19th, between the 12th and, I'm sorry, until the 12th. Between the 12th and the 19th, rebuttal evidence, responsive evidence, okay? And I'm sorry, Ms. Gould, I got it wrong and I apologize. All right, so 12th, new evidence, 19th, responsive evidence, 29th, final rebuttal by applicant only. This is the last time in this hearing you're going to get a chance. Are there any questions on logistics from the date and time perspective? And then I'm going to turn it over to Ms. Brewer.
Yes, and I'm sorry, Jeff Kleinman, and this is directed at Ms. Brewer. It's going to be really important, especially for that deadline of the 12th, that items get uploaded super pronto to Excella. Otherwise, people just won't have anything to work with.
Okay.
Understood. We're doing our best.
Okay. Ms. Brewer, floor is yours. Talk about the logistics.
Thank you, hearings officer. I just want to note that there is a hand up on Ms. Gould's screen. I don't know if.
I'm sorry, I don't see it. So, oh, there it is. Ms. Gould. So.
Yes, I just wanted to reiterate the issue is if documents are expected by 5 o'clock on a Friday, it seems to me that they're not going to get uploaded until the Monday after, which would be the 15th. So in terms of usability, you're then asking people to maybe get materials in the morning or the afternoon of Monday, the 15th, and you're expecting them to work 1, 2, 3, 4 days to turn around that information.
The response I'm making is yes, that is the case.
So you're feeling that there's parity with that in extending final legal argument to the 29th?
I do, because 2 of those days are holidays and 2 of those days are weekends. Okay. Ms. Brewer?
All right, thank you, Mr. Hearings Officer. So a couple of important notes here I'm going to read so it's accurate. So for the open record period, please keep in mind that the county does not retrieve information from a website or link or personal cloud storage device. It is your responsibility to submit all evidence and testimony you want the hearings officer to consider. All submittals must be addressed to me, and if we could put put the PowerPoint back up, my email address is on there. And I'll also give our physical address. Yeah, let's see, let me scroll. Let's see, is that the one? My screen's so tiny. Not that one. So this is what I'm reading to you right now. Yes, my email address is near the top there in blue text. So please direct them to me. Our physical address is 117 Northwest Lafayette Avenue in Bend, Oregon, 97703 at PO Box 6005. So you can send that to me directly, physically, or electronically, and we'll get that uploaded just as quickly as we can. Email submittals, as I mentioned earlier, that exceed 20 pages, include any color documents or include any documents that must be printed at larger than 8.5 by 11, must be submitted as a hard copy as well. Any electronic submittals must be received by the county server by 5 p.m. So please, please don't wait until the last minute to submit your evidence and testimony. We are, as Will mentioned, we are down an administrative professional position, which is causing a little bit of delay, but obviously we will do our very best to get things uploaded into the record just as quickly as possible. Mr. Hearings Officer already cited the deadlines very clearly. I've written them down, and I believe that captures the open record period requirements on our end.
Thank you. All right, any questions about the logistics? And Ms. Gould, I take note of your earlier comments when we started the hearing regarding evidence into the record. I know that it's not technically correct, but I will tell you that having been involved with this process a while, I have not been involved with many cases that had a sophisticated legal representation or clients or customers or people as Ms. Gould and Mr. DeLashmut and their counsel. I can't emphasize enough that those of you who are involved in this case stay in communication with Ms. Brewer. And if you have any questions about the process, any questions about submission, any questions about what's in the record, please do not hesitate to contact her. All right. So anything further before we move on to the next hearing?
Nothing
nothing, Ms. Brewer?
Nothing from staff, sir.
Okay, anything from any of the parties?
Not from the applicant, thank you.
Okay, Mr. Kleinman?
Oh, Mr. No one has raised their. Mr. Kleinman was demoted unintentionally. Are we bringing him back?
Yeah, I was just going to say he's not there, so he can't answer. I'm not aware of anything that.
The hand. He's on his way back.
All right. I'm going to ask staff. I'm sorry, who was speaking?
Sorry, Mr. Hearings Officer. This is Angie Brewer. Jeffrey Kleinman is back online if you wanted to ask.
Are we going to take a few minutes between hearings?
That was, well, great minds work in the same direction. And so I'm going to ask Ms. Brewer, because Mr. Kleinman, you and I have a feeling everyone else can put yourself on mute and get rid of the video and run to the restroom. And Mr. Katzeroff can say hello to his dog, but Ms. Brewer's stuck where she is. And so I want to make sure, Ms. Brewer, would you prefer to take a break? And if so, how long?
I am okay for a quick break. Let me check around the room. Support staff, 5-minute break is what's being asked. If it would be all right to keep it to 5, that would accommodate staff.
Okay. Yeah, and I'd like to stay rigid to that 5 minutes, because based on Mr. Kleinman's comments earlier in this case, he seems to think that the next case is more complicated. And if that be the case, I want to make sure we have ample time to hear everyone's testimony, including applicants and appellants. So we will, Ms. Brewer, you will get us back on in 5 minutes.
All right, 9:05. We'll see you at 9:05. Thank you.
Thank you.
Thank you. Thank you.
You can de-elevate Carl, Ken, and Jeff. And you confirm with Greg, you're ready to give your presentation.
Okay. Mr. Hearings Officer, we're ready when you are.
I'm ready at this time. You may start with your comments if you'd like.
All right. Well, just to be abundantly clear, we're initiating the public hearing for file number 24721-0000553 MC with the appeal file 24721-00055, 920A attached to it. This one is specifically to amend the conceptual master plan and final master plan for the destination resort to conform to state and county destination resort rules regarding overnight lodging units. It's specific to the ratio of overnight lodging units to single family dwellings. Those rules have changed since the original master plan approval. The applicants are Central Land and Cattle LLC and Cameron Delashment. The appellant is Annunziata Gold, and the properties impacted by this decision are listed there for you. Before we get into the staff presentation, I think we're going to do an abbreviated version of our last run at identifying who's interested in providing verbal and oral testimony. If we could just get folks to raise their hands to indicate whether or not they're interested in providing comment, we'll write down your names right now, and then we're ready. When we're ready for the hearings officer to call up those individuals, we will call on you. So I'm seeing, I'll just call this out for the list right now. I'm seeing Ken Katzeroff, Susan Strauss, Carl Anuda, Paula Latassa, Jeffrey Kleinman, Nunzi, Ms. Gold. I'm sorry, I'm reading straight from the list here. We lost a couple. And now let me get to the attendees. won't let me. Was that all of them? Okay. I didn't know it, it's switched over me. Let me write these down really quick.
Could you ask everyone to please raise their hand one more time?
Yes, thank you. So just to make sure I've got it written down, please keep your hand raised for just a moment. I can speak faster than I can write. And okay, thank you very much. Okay. All right. Got it. Thank you. You can lower your hands and we'll get into the staff presentation here. Lower these. So this will also be brief. I will be relying on the applicant and the appellant to share sort of the complex nuances of the case. The appeal is largely related to concerns the applicant has not met their burden of proof. They cite concerns with the goalpost rule, ORS 215-4273A, and substantive changes to the site plan that require a new application. As promised, very brief. I am available for questions, Mr. Herring's officer, if you have them, and otherwise I'll turn it over to you.
Thank you, Ms. Brewer. As much as I'd like to, considering the history of this case, I am reluctant to shorten up my opening comments, which means that any of you who have heard this before may want to take a break, but I'm going to go through it anyway. This is a recorded hearing. The hearings this evening are quasi-judicial hearings before a Deschutes County hearings officer. As I indicated earlier, if you testified in an earlier hearing and just want to sit on the sidelines this time, that's fine. But if you had something you said in the earlier hearing that you want me to consider in this hearing, you're going to have to bring it up again. And if in fact you submit evidence into the record that you want in the earlier hearing and wanted in this hearing, you're going to have to do that once again in this particular hearing, case file number. As I indicated in the earlier hearing, my name is Greg Frank. I am a contract hearings officer for Deschutes County. I indicated in the earlier hearing that I am familiar now. I can't say what I did in the first hearing. Ms. Brewer now has presented the hearing before me as the primary planner. Mr. Groves, who spoke during the earlier hearing, I've had hearings with before. I have had hearings before with Mr. Kleinman, now with Mr. Katzeroff, Mr. DeLoschmidt, and Ms. Fancher I see on the list. A number of the folks who testified in the earlier hearing, including Paul Latassa and Ms. Gould, have testified before me. Once again, I have no personal, financial, social relationship with any of those folks and do not believe that my prior contacts will impact any decision in this particular case. As I indicated in the earlier hearing, I have now had 2 Thornburg hearings, as opposed to what I said in the earlier one to just one. I issued a decision which, based on Mr. Kleinman's testimony, has been appealed or will soon be appealed to the Land Use Board of Appeals regarding Phase 1's tentative plan. As I indicated earlier, my decision in that case, my consideration of the case that we just heard, I do not believe will impact my ability to make an objective decision in this case. In every single case that I've been involved with, and this will number close to 700 land use hearings, that I have never had anyone indicate that I was biased or had a conflict of interest, and I'm not about to start at this age. So I promise you that I will look at the evidence and the laws in that are relevant in this case and make a decision based on those relevant laws and the evidence that's related to those. I am going to suggest once again that the applicant's team, the appellant's team each have 30 minutes max to present their testimony tonight. As I indicated in my earlier hearing or in the earlier hearing, I fully anticipate that the record's going to be requested to remain open, and I'm not trying to preclude anyone from the opportunity to present any evidence or argument they wish, but I do wish that we would be efficient tonight and be precise in our evidence and argument presentations. I would also suggest that other persons testifying, whether in support or in opposition, be given 5 minutes. As I did in the earlier hearing, I'm going to ask whether or not anybody, by raising your hand, objects to those 30-minute time limits or the 5-minute time limit for other testimony.
No hands raised on this side.
All right, well, that's nice. So I'm hopeful that we can stay within those time limits. As I indicated in the earlier hearing, I have not done a site visit, nor will I do a site visit. The information I have about this case is going to be generated through the record of this case only. As I indicated, I do not own any property that would directly, or in my opinion, even indirectly, be impacted by a decision in this case. I do not have, as I indicated, any personal, business, social, economic relationships with anyone except for those that I have announced earlier. I noted in the earlier hearing that I last reviewed what was in the public record as of 2 o'clock today on November 4th. And I will note, as I did in the earlier hearing, that I did review the administrative or staff decision. And I also reviewed quite carefully the documents submitted, the appeal documents submitted by Ms. Gould and Mr. Kleinman. My job in this case, as in all cases, to consider whether or not federal or state or Deschutes County laws actually apply. And if so, to consider in those laws context, all relevant testimony and written submission. I believe I have no personal bias or prejudice in matters related to this case. I believe I can make an objective decision in this case. At this time, I'm going to ask that if anyone has an objection to me continuing with this case, hearing the case, deciding the case, I wish that you would raise your hand and I will recognize you and listen to your objections.
Seeing none on this end.
All right, then I will proceed in hearing the case and making a decision ultimately in the case. As indicated in the prior hearing, the applicant has the burden of proving that the applicant is entitled to the proposal sought, which is referenced in DCC 22-24050. Please, and I kind of emphasized this earlier, please direct your testimony as best you can. And I take note that Ms. Larson in the prior case indicated she was not a land use expert, and some of these processes or laws or procedures are confusing. If you have something to say it. But if in fact you're experienced in these kind of matters, particularly the counsel for both the appellant and the applicant, stick to what you believe is the relevant approval criteria and direct my attention to evidence in support or conflict with those. Repetitious testimony comments that I made in the earlier hearing still apply. If somebody's already said it, say I agree with them, or if somebody's already said it, then please disagree if that's your feeling. But I don't need to hear everything 2 or 3 or 4 times because saying something twice doesn't make it any more or less true. I read this at my last hearing, and I'm going to have to read it again, and I apologize, but failure on the part of any person to raise an issue with sufficient specificity to afford the hearings officer, that's me, or other parties to this proceeding an opportunity to respond to an issue will preclude an appeal on that issue. Additionally, failure of the applicant to raise constitutional or other issues relating to approval with sufficient specificity to allow the hearings officer to respond to those issues precludes an action for damages in circuit court. The order of testimony will be the same as we had in the prior hearings, which is most of you have already heard. I will ask staff to give their presentation. Applicant's team will follow. Supporters of the applicant's position will follow. Any person next who is neutral will be able to testify following the neutral testifiers. Anyone in opposition, which certainly is going to include the appellant and appellant's team, and following that, anyone in support of the appellant's position. Following that, staff will be given an opportunity for closing comments. Applicant will be given an opportunity for rebuttal, briefly, I hope. Appellant will be given an opportunity for rebuttal, briefly, I hope. And if so given, then I will give applicant the final word and then give staff any final comments. We've already had a discussion in the prior hearing, but I'm going to repeat it very briefly. If you want the record to remain open beyond the close of the hearing tonight, when you testify, tell me. Just say, I want the record to remain open. And if so, we will discuss at the end of the hearing both the timing and the logistics of that process. Ms. Brewer will then get involved again with telling us how we do that and the dates and the times and all that. So with that, then I'm going to turn it over to Ms. Brewer. I will ask her to give the staff presentation. Following that, I would expect the applicant and applicant's team to make their 30-minute limit testimony presentation. Ms. Brewer.
Thank you, Mr. Hearings Officer. The brief presentation I gave prior to your information was essentially the staff report. There's nothing more, but I can certainly bring the slide back. The slide back here. This was the original slide we went through already. This is the file numbers attached to this hearing. Just a reminder to all that this is the scope of the issue here is an amendment to the master plan to conform to state and county destination resort rules regarding the ratio of overnight lodging units to single family dwellings for destination resort rules. There is no new staff report, just to make that clear. And again, we're relying on the applicant and the appellant to provide additional information. And this is again redundant, but these are the statement of reasons that the applicant has not met their burden of proof, that the goalpost rules were jeopardized, and that there were substantive changes to the site plan that require a new application. Do you, and here is where I would turn it over to you, Mr. Hearings Officer, if you have any questions for staff about the staff report or anything before we turn it over to the applicant.
I appreciate your comments. I have no questions at this time. Mr. Katsaroff, are you going to be the spokesperson again?
We're bringing him over right now.
Thank you.
Hi there, Ken Katsaroff, attorney, co-counsel for the applicant. My address is 1420, for the record, 1420 Fifth Avenue, Seattle, Washington, Suite 3400, 98101. I would say, unfortunately, we can't keep the 30 minutes. It'll be about 3 hours. No, I'm kidding. Sorry, bad joke. It's too late. I will try to.
There goes your deposit, sir.
I will try to keep my comments as brief as possible. Because at least from the applicant's perspective, we think that this application of this decision is quite simple, and as is readily apparent to us, at least, the appellant didn't understand what our actual scope of proposal was, and so on that basis, maybe we don't really have that much of a disagreement, although I'm sure I'll learn otherwise. The proposal before you is an appeal of a decision that allowed modifications to essentially put the destination resort on the same footing as other resorts in the county, and to apply the existing law, or the laws that exists today based on the county code and state law. Applicant is not seeking to change or increase the number of individually owned residential units that may be built by the resort. If we wanted to do that, we fully understand that we would likely have to do a modification to the CMP and the FMP, but that is not what we are asking for. The maximum number of units remains the same, and no new development will be allowed by the amendments requested. So most of the appellant's arguments are based upon this erroneous assumption. And so to the extent we may have just cleared it up, hopefully we can make this hearing a little bit shorter than the previous one. What we have asked for is to modify certain discrete portions of the FMP decision and the conditions to reflect current laws, not to change the amount of individually owned units or individually owned residential units. I filed yesterday, and they're on a sale today, a request for a correction to address a couple of errors in the administrative decision. And what I want to talk about on that basis is the code DCC 22-36040 permits the applicant to make discrete changes. For whatever reason, staff and the applicant have a little bit of a disagreement as to what that provision allows, and allows the county to modify as part of a modification request. We think that the decision goes a little bit too far, and in fact, certain requirements need to be reimposed in order to ensure that certain provisions of state law are met. In particular, that includes things like FMP condition 33, which assures that construction of dining, meeting, and recreation facilities occur during the Phase A development. And so, consistent with my letter dated yesterday, November 3rd, 2021, we request that certain conditions actually be retained. We also note that staff imposed certain changes related to tentative plan review rules, which are not relevant approval criteria to any of the changes proposed. So we've outlined in a submittal what we believe should be the correct changes of conditions, and requested the hearings officer consider that. Now, getting to Ms. Gould's appeal, beyond the assumption that more individual lots are proposed, they're not. We would have to say the Gould's argument that the goalpost rule somehow bars modifications is simply incorrect. It's also not consistent with the purpose or intent of that statute. That law requires that the law in effect when a modification application happens is the review criteria. Modifications of approvals are specifically allowed under the county's acknowledged comprehensive plan and zoning ordinance, and are measured against the law in effect when the change is requested. We've complied with that. We're merely asking that this resort is on the same footing as other resorts in the county. And I would note that the Oregon Court of Appeals has already determined that the county can approve this exact type of amendment for resorts previously approved under the different OLU ratio of the 2-to-1 versus the 2.5-to-1. That was the Central Oregon Land Watch versus Deschutes County case. And I think the citation is 285 or app 267. It might be 367 though. I think I have a scrivener's error in my own notes. But the point is that the Court of Appeals has already determined that a modification exactly like this one is permitted. I would also like to address briefly the modification code, particularly as it's different than the modification for CMPs. So the controlling provisions for modifications of this nature, what we're doing here today, is DCC 22-36040. There is a separate provision of the county's destination resort code, DCC 18-113-080. That provision explains the type of review, but not the grounds for approval of requested changes. I'd also note that DCC 18-113-080 applies only to changes in the development plan itself, none of which are proposed here. In fact, the condition says that a substantial change is an alteration of the type, scale, location, phasing, or other characteristic of the proposed development such that the findings of fact on which the original approval was based would be materially affected. That's not being requested here. We're asking for some specific changes or modifications based upon the ratios, bonding requirements, et cetera. And so I've outlined those in my letter dated yesterday. And we think that, or we requested the hearings officer apply those as we've asked. The last thing I would like to talk about is, again, there's this perceived issue on a lot of record where Ms. Gould and sounds like Central Oregon Land Watch has submitted testimony that there isn't a legal lot of record, or that there was a mistaken conveyance that somehow now prevents any sort of development, and that's simply not the case. LUBA has made it clear that a deed alone does not create a new parcel. And in fact, in a previous hearing earlier tonight, Central Oregon Land Watch representative said the same thing. Deed on its own does not create a legal lot. So in this case, we've got legal lots as has been determined by the Board of County Commissioners, and that's final and binding. So I don't have anything else I would like to talk about tonight in the interest of keeping this brief. However, I would request that Cameron DeLashmutt be elevated in the event he's got remarks on this particular application as well. I obviously would also be happy to respond to any questions the hearings officer may have.
Just one, I did review for all, because I received it prior to 2 o'clock today, a copy of Mr. Katzarov's November 3rd, 2021 letter. So I did review that, just disclosing that. It also in there, and I'm looking at in particular page 4, and there's a reference to Caldera.
Yes, sir.
And so I believe that was exhibit 102, and doesn't talk about the ratio, it only talks about the number of weeks, as I recall. Is that your understanding?
I believe so, yes. The point is that
okay, and there was also
you're breaking up a little bit for me. I'm not sure if it's my internet or yours, sir.
No, I'm not sure. All I was concerned with is the Caldera decision from your perspective simply talks about modifications, not specifically the ratio or the bonding requirements. It only relates to the number of weeks. And that's using that as a precedent.
It's using that for the idea that modifications of this type can apply, and that a change in the FMP is permitted in this sort of an instance. There's a disagreement between the appellant and ourselves as to whether or not the ratio already automatically applies based upon what the code says that it already applies. And so we, in order to kind of, I don't want to say clean it up per se, but to clean it up is to say this is the ratio that does apply to this resort. I'd also say that there are 2 different Caldera applications, and so to the extent we've managed to confuse you, I apologize, and we'll certainly address it more in our submittal that will, I'm sure, be due as a result of the record being requested to be open by somebody who will be testifying later.
All right. It would be helpful because I believe in your letter there was a reference to Tethro as well, but I didn't see any case. And keep in mind, I got this just before 2 o'clock, and I have not had an opportunity to review it in great detail. But when I saw in your letter that you were citing additional Deschutes County developments, resort developments, and the modification as it relates to both the ratio, the number of weeks, and theoretically the bonding requirements, it perked my interest. And if there is legal support for that, I want to know it. And the way I read the Caldera case that was Exhibit 102 is it only related to the weeks. And I didn't see in Ms. Gould's arguments, the number of weeks was a primary concern. Her argument seemed to be focused, and she's going to be able to speak for herself as well as Mr. Kleinman and Mr. Nuda. But it seemed to me that she wasn't as concerned about the number of weeks as she was the possibility of creating additional residential units or the impacts perhaps even for reducing the number of the OUs. And so I was looking for precedent, didn't see it. And I'm just letting you know that is a concern. I didn't read the Central Oregon Land Watch case that you cited, but I will do so. All right, that's all I have, sir.
All right, thank you very much.
Yeah.
I don't have anything to add on this application.
Okay, thank you, sir. Anyone else wishing to speak in support of the application, in support of the proposed modification? Ms. Brewer, anyone?
I'm looking, I don't see any hands raised.
All right, thank you so much. I didn't mean to hurry. I apologize. This will be the time and the place for the appellant's team. I don't know who's going to climb in, but I'm open to whoever is representing and wants to speak first.
Let me elevate Jeffrey Kleinman. And Carl Anuda and Anziatico. We're elevating them.
You can de-elevate, Ken.
Here we are. Good evening again, Mr. Hearings Officer and Angie. I can tell you, whoops. Let me adjust the volume so I don't blow anybody's eardrums out. Okay, can you hear me?
Yes, I can, sir.
Okay, and not too loud. We carefully reviewed the application and the staff report or decision that we've appealed here, and certainly did see nothing relating to the change in the OLU ratio, which would not allow for substantially more single-family dwellings. In fact, we've had a lot of trouble understanding how many freestanding single-family residences are permitted under the approved final master plan. The best we were able to come up with was that it was 300, and it would be allowed to be 375. Mr. Frank, can you hear me? You've kind of faded out there.
Mr. Klein.
Yeah, you're coming back.
And I can hear you fine.
Okay, thank you. So
That's because I had my volume off.
Well, the image went away as well. So
well, I did that on purpose. We're supposed to focus on you and not me. You're speaking.
All right. Well, so by our calculation, they were approved for 300 homes, not the 950 that Mr. DeLashman mentioned in the last case, and it would go up to 375. Now, if the ratio is changing, as we read the application and the staff decision, it would go up by 237 additional houses. What Mr. Katsaroff is saying is that actually we're misreading everything, and the number of single-family residences will stay the same as before, but the number of overnight lodging units will go down. And I don't think that's clear from the application, and it's certainly not clear from the staff report or the proposed conditions of approval. So I think what would be most helpful would be to get some more information on the record. And that would be a demonstration by the applicant of how many homes were allowed under the final master plan and its conditions of approval, which is sort of mysterious. And how many OLUs were required, which is far less mysterious, and how many OLUs they are now proposing. Along those lines, what is going on here, of course, as we have said, both in the initial case you're involved in, and I'll say it again, is an effort to create a McMansion residential community outside Redmond and not a destination resort. And once we see what is actually proposed and what stipulations are proposed to be put in the decision that satisfactorily controls the scope of the development, then we'll comment further on rebuttal. But again, that would require a showing of what has been allowed, and a showing of what is proposed, and a showing of the specific conditions of approval that would be necessary and that they are agreeable to, that would bring that about. We will reserve our arguments. Well, I shouldn't say reserve, we will preserve the arguments that we made in our statement of reasons for appeal and that we made earlier today, but after you last had a chance to look in a separate memorandum that I filed for this hearing, and separate memorandum or letter from Mr. Onuda. And we also, in both of today's cases, filed two technical memoranda from Mr. Lambie. Filed them separately so they would be in each record, and we'll stick with what we said there. I do want to, before I forget, again request that the record be held open. I have a different proposal this time that avoids all the holiday mess. As a preliminary matter, I would ask Angie, what are you showing, please, as the 150-day limit on this one?
Ms. Brewer, you may respond.
Thank you, Mr. Hearings Officer. This one has the same timeline as the applicant told the timeline as well, so that the start clock was reset. So the 150th day in which we must take action is February 12th, 2022.
Thank you. I still think that a reasonable open record period is necessary to sort through these issues, and will still give the Board of Commissioners plenty of time to make a final decision by that date, especially considering that they would have additional time to adopt their findings. But obviously there are some odd issues here, and there are two ships crossing in the night. I hesitate to say that. I once said that to a judge, and he said, well, isn't that always the case? But in any event, in order to avoid the holiday mess for everybody, we would propose 14-day open record at both ends. So November 18th for submittals, including new evidence, December 2nd for rebuttal, including rebuttal evidence, and December 9th for the applicant's final argument. And I do think that gives plenty of time to get this to the Board of Commissioners if necessary. So I will reiterate that based on what Mr. Katzeroff said, it would appear that what this is all about is simply a reduction in the number of weeks of mandatory rental. So again, it'll be less of a destination resort, and people can hang out in the units they own more than they could otherwise. A reduction in bonding and less overnight lodging units. We have seen that nowhere in the materials that have been published to date. So I would strongly encourage the applicant not to wait for rebuttal, much less final argument, but to set it out in the way that I explained in the initial open record submission. How many homes, how many single family residences are allowed under the final master plan, and how do you get there? Number one. Number two, how many OLUs are you now proposing? And that's still going to leave the question of whether this is a substantial modification, and we can fight about that if we need to. But let's see what this really is. I don't think the hearings officer, I'm not going to hopefully be too presumptuous, but I don't think the hearings officer, having read our arguments and our statement of reasons, jumped to the conclusion that we misunderstood everything, and that this is, a request that's relatively minor in the manner that Mr. Katzeroff just described. Because if it is what we've read it to be, then for the first time, we would legitimately be seeing an impermissible collateral attack. But it would be a collateral attack by the applicant upon the CMP and the FMP that they fought so hard to get approved. And in that case, certainly the legal issues we've raised would be directly applicable, and it is a do-over. So let's get all the cards on the table in a way in which they can be incorporated into a possible decision, and we'll see where we go from there. I am not prepared on behalf of my client to make any assumptions or take for granted what we've heard. And I don't mean to cast aspersions on Ken, but this truly is news to us, and we're going to have to see it. With that, let me look quickly through my notes and see if I have anything to add. Okay, we will adhere to the matters set out in the statement of reasons for appeal and in the memorandum we filed late this afternoon, in the submittals from Mr. Anuta and from the certified water rights examiner, John Lambie. And as I say, and I'm sorry to repeat myself, let's see what this proposal really is in a way that would be binding. And we'll take a look at which of the approval criteria we feel would still be applicable. With that, let me turn this over to Mr. Anuta, unless Mr. Frank, you have any questions.
I have no questions, Mr. Kleiman. Thank you for your testimony.
you.
Mr. Anuta?
Thank you, Mr. Hearings Officer. Before I touch on the water issue directly, I want to point out that this is a very interesting development, that in fact, the applicant is saying there will be no increase in the number of development units or individual units. If that's the case, I'm sure they will propose a condition of approval that specifies precisely that and is totally clear. And I'm hearkening back to a case I had in Salem where the developer proposed a rezone and represented to the city council that they would never build a big box store or any gas stations. And the city council in Salem relied on that. But no condition of approval was ever written that said that. And so after the 2008 recession hit, the developer sat on things for a while, couldn't sell the property, and then came back with a proposed Costco and a 30 pump fueling station. And when the city council turned it down on the grounds that they had been represented, that it would never be that, the developer took it to LUBA and said, doesn't matter what we said, there's no condition of approval. We get what we want here because this is within the rezone. And ultimately LUBA said, that's right. So if the applicant is really legitimately saying there will be no increase, we're only trying to do this to reduce our OLU, great, let's see the condition of approval and see if it really says that. I gotta think that they're definitely looking for some sort of change or they wouldn't be proposing all of this. Whether it's a change to more units or less units, I guess we have to see, but they wouldn't go through all of this if they weren't fundamentally trying to change something. And if it in fact is a minor change, then that we may have a lot less to talk about. On the water issue, my materials that I submitted on this one issue raised the same issues that I raised before. There's a huge water availability issue. The materials lay out that out. There's the permit that they have is not a valid permit in terms of being able to use water. It's not a canceled permit, but we don't think they can pump a single bucket out of that legally because they never used it beforehand, before it expired. I would note that we talked in the last hearing, and I mentioned in my materials extensively and attached a copy of the water management conservation plan that the applicant filed with the Water Resources Department. That plan specifically was used, it was calculated based on the current number of units that the application shows, not on some different number, whether it's more individual units or less individual units. The plan wasn't calculated on a change. It was calculated on what was previously proposed and approved. So that plan, in fact, estimates an extraordinary amount of water to be used, and that, at least in this part of the country, given the dropping water levels, that plan will need to be redone. And the county staff report, to the extent that it relies on that plan, may be making some faulty assumptions about the water use here. I would also note that the county staff report, apparently the applicant failed to mention to them what Mr. Delashmutt acknowledged in the last proceeding, that the WMCP itself has actually now been withdrawn, and it has no legal effect in terms of being able to bind the applicant. That ultimately is something that the staff may need to look at seriously, because if they're relying on the WMCP calculations and water usages, those aren't locked in anymore. And perhaps if the applicant is proposing less water consumptive uses in this modification, which seems unlikely, since most of the time single family residences, if you're building more of them, require a heck of a lot more water. So it sounds to me like they might be almost proposing more consumptive use. But in any event, the staff will need to look more closely at that. As I outlined in my previous materials and testimony in the other hearing, we think it's unlikely that the applicant's going to get any of the currently pending permits. I should also note that the applicant recently got a Lux land use compatibility statement approved by the county for some additional permit of some sort that it's going to be potentially proposing to Water Resources. We haven't seen that application at Water Resources yet, so we don't know precisely what's proposed, but it's yet another effort to get additional water above and beyond the existing 6-well permit that's expired and to use it at this site. So we're hopeful Water Resources will say, we already said these wells in this area can't support that. There's not water available within the capacity of the resource. But at least at the moment, we don't think the applicant has demonstrated that they have the water. And as Mr. Kleinman outlined in his materials, we think they have to demonstrate that at each and every time they change things. And this is a change. That's all I've got to say. And my materials lay out more detail, obviously, but I don't want to repeat myself.
Hello.
Thank you,
Greetings.
Mr. Anuda. Ms. Gould, this is your opportunity.
Yeah, I think it's pretty preposterous what you've heard this evening. And again, one of the challenges on giving public comment is having a complete application. So we're hearing today, at the time of the public comment, that the application just submitted yesterday, something into the record that's different from what it applied for, or that the staff misunderstood what was applied for. I would request that we actually have a public hearing when the file is deemed, the application is deemed complete by Angie. So we already had a letter that went out saying that the file was incomplete. Then we go through this whole iteration of creating a decision, and then the applicant comes back and says, no, you really didn't understand what we were trying to get at. So is the applicant appealing the decision? Is that what's being applied for here? Or is there now a modification of what they applied for back in June? So it's preposterous. This whole resort since 2005 has been dealt with in this whole shell game methodology. And to say that this is just discrete changes is absurd. It's obscene. There was a change in state law, and these guys want to be on the bandwagon. And these guys were not part of the application when all the other resorts in Deschutes County wanted to implement that change. This particular resort was not in that lineup. And now you're hearing that they kind of want to be in the lineup, but it's just kind of discreet, and it's really not going to be the houses or the OLUs or whatever the heck it is. Trust me, they want the full open accordion. They'll minimize it, Officer Greg Frank, and I hope you would turn on your video so I could see that you're actually present at the public hearing. But let me give you a for instance. A small OLU at Eagle Crest can be on 0.06 acres. That's probably something similar to your condominium at Sun River Resort. Now, a larger home at Eagle Crest can be on something like 1.25 acres. And the result is you end up with a humongous house on a much larger lot. And it's not going to have a minimal number of bathrooms for instance, a 1-bedroom lockout that might have 1 bathroom. On a large home site, you're going to have 4, 5, 6 bathrooms on these large homes. And the effect of that, in addition to the large lawn that goes with beautifying these large homes, is an increase in water consumption. And that's why the OLUs are factored at a certain water consumption rate, and the homes are factored at a different consumption rate. And that was meted out in the course of this application, beginning in 05 and in 08 and through the extent of the final master plan. And it's absurd. It is absurd today to be considering that this is a discrete change. And in the face of this particular year where our county declared a drought in Deschutes County, the earliest I've seen declared in my 30 years of living here, it is obscene that the staff and the hearings officer and even the applicant described this as a discrete change. Obviously, the standards allow 25% more homes and a 25% more homes and a 20% reduction in overnight lodging units. In other words, it's less of a rentable destination resort. That's the net effect of all of this. The other thing that is most critical is that the CMP and the FMP identified phases. They never identified sub-phases in this discrete way of this particular resort wanting to evolve in its own iteration and wanting to take Deschutes County and the hearings officer with it. We need these things based on phases, and we need them based specifically related to homes and OLUs. And amending this thing is a total goalpost change. This resort is the last to get to the table. This resort, unlike what Angie testified on public media, is not like any other resort. This resort is much bigger. This resort is not near where we have cities. And this resort is not tapping into cities' water as Tetherow is, as a for instance. The groundwater extraction from this resort is at a location very different from Sun River. Okay, it's not flat. The Deschutes River is not in visible view of your condominium, Mr. Frank, or when you walk from your condo, you're not near the artificial lake or the Deschutes River. The point is, this is a vertical butte, and deep, deep wells are proposed, 1,500 feet deep wells. That's not a little irrigation well, okay? That's not even the 700-foot well that's on the resort that they're supposed to be filling with concrete and abandoning, according to the CMP and the FMP, which they have not done. Okay, so let's get things straight. Klein Buttes is not flat, and the impact from withdrawing water at Klein Buttes is something that has been modeled, and that's why this resort is so different, Angie and Officer Frank. It's so different from all the other destination resorts because they never modeled on the USGS, and they never showed, as this resort now is connected to the Yinger report that shows the hydrologic connectivity between groundwater withdrawal, aquatic fisheries, cold water spring refugio, and that's why there is a fish and wildlife mitigation plan in addition to the wildlife habitat plan. And the annual report that is needed for those, where is that today? As we trickle along 15 years later, where is that report? So let's talk about the difference between the 0.06 acre OLU and the 1.25 acre home site. When you develop that large home, you're taking out more trees. You're adversely impacting the wildlife habitat on that property. And we need an evaluation of the impact on the wildlife habitat from this type of a grab. It isn't just water, it's the impact to the wildlife habitat on the site. Now, if you don't believe me on the wildlife habitat impact, that's something that is supposed to be identified for where it will be mitigated. And right now, today, we do not have that known. And today, old growth trees are being yanked out left, right, and center, Officer Frank, and stacked higher and longer than a football field. So we have adverse impacts to wildlife habitat today in the face of this construction. where apparently they're supposed to be doing dust mitigation and there have been water trucks, but they don't have a water permit. So it is high time for Deschutes County to be doing a site visit. And I highly encourage you to show up here in Deschutes County. You won't catch COVID because it's 1,970 acres that you can travel on to see the impact of this destination resort. And the modification that is being asked for is clearly a goalpost change. And that is inappropriate until such time as all the other iterations that came with the open space calculations. Imagine 0.06 on an OLU compared to 1.25 on a large lot at, I'm just throwing out one from Eagle Crest as a for instance, okay? There are larger lots at Tetherow. There are lots that are 2.5 acres at Tetherow, okay? So the lawn that goes with it, the trees that get demolished in the course of the driveway, the building the site, and all of the other artificial amenities that everybody seems to think will just do just fine here. The reality is they don't make it because it needs total artificial support. This environment here is aridifying. If you're not familiar with that term, it means that our high desert is getting drier. And what people in our community want is our water resources to be used conservatively, conservingly, and not spewed for these artificial, idiotic developments in the desert. So on that note, we need wildlife habitat evaluation. We need homes to overnight documentation. It has to be done by the phases within the development. And if you were listening to the last application, the 508 site plan, they don't want to be beholden to where the sites actually are. Furthermore, this resort allows land to be annexed in, and that is increasingly problematic when it comes to exactly how many homes could be included in. And if you're not familiar with those, I highly recommend you look at the road maps, specifically the road that's supposed to go up and over the ridge to connect Eagle Crest Drive to Klein Falls Highway, as a for instance, so that you can see the connectivity on this whole thing. So I hate to get a little bit revved up. You know, I do have curly hair, but this resort is always asking for more in advance of it even getting its own current approvals. And it's problematic. And for a new planner like Angie, who just got hired on to take on from the reins of Mr. Groves under the county that hasn't yet assigned a new planning department head, in the face of all of these additional changes, and also in the face of how things are uploaded to Excella. And I encourage you to look carefully at which records are uploaded to which files, because there's all kinds of spaghetti that the county is succeeding in doing on these things. So it's high time for Deschutes County, okay, to understand that citizens are upset with Deschutes County because the buck stops there, and people are not wanting these egregious changes in our rural environments at the expense of people having to deepen their wells because the idiotic well indemnification agreement only goes 2 miles. Well, let me just say, the resort is 2 miles east-west and 2 miles north-south. And it basically means that the well indemnification would not actually indemnify anybody. So next time you spend $40,000 to deepen a well or drill a new well, it might put some real cost in the mind of what the public is talking about when they say, I'm worried about deepening my well. It's very real. And the OLU standard, for however preposterous or whatever word did I get from the testimony, a discrete change. This is not a discrete change. And I will just stop there.
Then I don't even have to say anything more. I appreciate very much. And I apologize if taking off my video offended you. As I indicated to Mr. Kleinman, my concern is that I want to focus on the person who's testifying. I don't leave here, as I indicated and asked Ms. Brewer if they needed a restroom stop. I don't take a restroom stop during the hearings. I listen, I take, as Mr. Kleinman will tell you, he in fact has been at my hearings at the city of Portland when I was there. I take voluminous notes. In fact, I think sometimes it offends people because at that particular hearing location, you could hear my little fingers on the keys. And it was, so I am listening. I appreciate your testimony. What I would hope that all folks concerned with this case, including anyone who's going to testify, is that we kind of try to stick to the issues at this particular case and not rehash history unless it relates to this specific case. But I very much appreciate your testimony, and it's okay to be emotional. That's
Well,
okay.
Mr. Frank, the reason I bring this up is you are not the first hearings officer on the resort. In fact, I would encourage you to count how many hearings officers there have been, how many staff planners there have been, how many planning directors there have been, and how many changes in the Board of County Commissioners there have been. And in the course of this development, the whole point of the CMP and the FMP is a roadmap that you follow. And it shouldn't just be thrown up in the air like helium balloons that just fly off. The objective is so that there is continuity.
I'm going to have you stop there. I appreciate very much your testimony. And my hope, as I indicate to everyone who is in my hearings, is that I only consider what the relevant laws and rules are, and I consider the evidence that relates to those. And I'm hoping that I'm not considered someone who just throws things in the air and picks things out randomly. I am stuck with what the relevant laws or rules are. That's why you have an attorney. That's why you testify, and that's why Mr. Anuta testifies as well as others. Is I want to know what those rules are, and I appreciate it. So let's move on to anyone else wishing to testify in support of the appellant.
So, Mr. Hearings Officer, we had Paula Latassa raise her hand earlier.
Okay.
Thank you.
Will you de-elevate Jeff, Nunzi, and Carl?
Hello, my apologies for the delay. I really cannot say anything further other than I fully support what Mr. Anuta said and what Nunzi Gould has said. While there may be some things that you personally find irrelevant at the moment, nothing of their testimony is irrelevant to the reality that we, as long timers, as users of this river, experience. The water levels that we see as recreationists, as growers of food, the availability of our water is of high concern. This development has not been transparent in what they fully intend to do. They are putting forth a project in the guise of LOUs, which might only be somewhat consumptive and that fall under a destination resort rule when really what they're trying to do is develop homes that will, as Nunzi alluded to, can be consuming much, much more water than some sort of an overnight rental. So I would agree 100% with Nunzi said, and that is we really can't make a full decision on whether or not anything should go through until we have a full comprehensive plan of everything that is included, that we know is included, including 3 possible lakes, all kinds of golf courses. This is not just a proposal for homes. We need to be transparent here. The game needs to be over. We know what's going on. And Officer Greg, the rules are the rules, but the reality is the reality. And you need to look at the whole picture. Just because somebody knows how to lay their deck of cards in a way that lets the rules skirt the resource realities, what is really possible for our ecosystem to sustain, doesn't mean they're right. So you need to listen to your heart. You need to listen to what's right. I, as Nunzi have been involved with this for over 16 years. I started as a parent at Tumalo Community School, where I knew at the time when they proposed this resort in 2005, the school didn't have the resources to support those additional potential students of full-time residents. I knew that those same homes wouldn't even pay the tax dollars into the system. Do not piecemeal this. It is a holistic issue. Do not let it come across as a piecemeal, project by project guise. We need to look at the reality, the system, what our community, what our natural resources can support. Thank you for my time.
Thank you for your testimony. Ms. Brewer?
Susan Strauss? On her way. And following her will be Rima Givot.
You can de-elevate Paula.
So, Officer Greg, I just I just want to say I have tremendous support, feels tremendously educated by Nunzold in what she presented. And I agree with her. I've been very educated by Carla Nuda's presentation also, in particular about the water resources. I just wanted to say that, I'm one of these people who had lived here 30 years, and there've been people around me who've lived here longer. So it's very painful for us, I think, when you have a planning department which changes people frequently. So you have to sort of, those of us who have followed this issue, as Paula had said, I remember when this first was proposed as a destination resort, and all of our neighbors thought it was crazy, it'll never happen. One little thing I can put into the record is that the actual history of Klein Butte, as Nunzi pointed out, this vertical butte, which has this extremely porous soil, in I think the late 1800s, there was a man named Laidlaw that had dug a whole bunch of irrigation canals there. Today, they're historic. You can go there on the BLM land and see these historic canals. Well, Laidlaw had dug some of these canals and sold a bunch of land to farmers to come to Klein Butte and farm, and he was going to provide the water for it. And Tumalo Reservoir was going to be part of that water. Well, he never was able, the soil could never hold the water, and he could not provide it. And he ended up being shot. That was the Wild West in that time. So it's bizarre that today now we all are gathered around to this absurd use of water. And so that is a little bit why we get kind of emotional, because we've been living here, building our lives. We have our wells, we have our crops. Some of us make a living from our crops. Some people have hobby for horse farms. Some of us pay full taxes. Some of us have tax deferral because it's farm use land. And this is our community. And so we have to explain over 15 years again and again what this means, that we don't want to have 1,000 or plus or 3,000 new cars driving on our rural roads. I've heard the term rural used so many times as a political ball, justifying something because of it being rural, but we are truly a rural community. And this is not this kind of huge water consumption. And I just want to say, not to sound too, one other thing, just what it means when you're outside working your field and dragging irrigation pipe in 108 or 110 degree temperatures we had this summer. That's an incredible thing. And when the fires were burning and you cannot breathe the air because it's toxic, and you go inside and you try to survive in air conditioning, but you cannot even at night seem to get enough oxygen from that kind of fire, consuming the oxygen in the air. So it's a very visceral experience, losing your water. And that's the best I can say to it. On a very mental note, I'll just say, I know for a fact the USGS did a very important survey some years ago that talked about the dropping groundwater levels in this area. And I want to find that and put that into the record. I also know my new neighbor, who is a retired hydrologist, wish he could have been here tonight, and I'm going to try to get him to make some comment, because he was horrified to hear about especially golf courses and artificial lakes in this soil around here. So I'll try to get that and submit that into the record. And thank you for your patience. Thank you. That's all I have to say.
I appreciate your testimony. Ms. Given?
Thank you.
Hi, thank you so much for hearing me again. I wanted to reiterate some of the things I said earlier and maybe add to that as well. In May, a statement came from the state that the claim was that the current drought wasn't having a direct impact on the groundwater, and yet we are seeing groundwater decreasing in this area. According to local well drillers, 3 wells a week are going dry or needing to be deepened in this area. That aquifer is connected to the aquifer that Thornburg is proposing to drill into. So groundwater is decreasing. If it's not directly affected by the local drought, that means it's impacted by what's changing, which is the increased number of wells being drilled in the area. More private residences, so changing their application to having more private residences instead of lodging for guests to come in, will only increase the amount of water needing to be pulled, which there really isn't available in our aquifer. Furthermore, this local aquifer is connected to springs like Alder Springs, which feeds habitat of Waichus Creek and the Deschutes River, as well as other local springs. Those springs pull from that aquifer as well. And I do not see how they're going to mitigate pulling more water from the groundwater and therefore preventing the water being pulled from those springs, which feed the habitat. I am also concerned, based on the comments already said tonight, that they actually even have permits to drill wells to pull so much water, and I think that needs to be thoroughly vetted. Furthermore, if currently local homeowners are having to deepen their wells, and when that happens, that means, and new wells are being drilled for resorts like Thornburg, the local long-term landowners are therefore subsidizing the drilling of new wells for new resorts. I'm curious how the water is going to be metered to make sure that it is equitable, how much they're taking, even if they're allowed to drill these wells. And also my concern is that if indeed it's only 2-mile indemnification, that seems ludicrous because, and completely irrelevant, because the aquifers are connected by far more than 2 miles. The entire aquifer of the area is much larger than 2 miles in radius. And so what is taken within that area will affect much further areas, much further than 2 miles away. In addition, habitat degradation is a very large concern. That area is part of wintering ground for deer and elk. And as that area gets diminished, that just pushes and pressures the local native populations of deer and elk. Also, old growth juniper landscape, native landscape, provides habitat beyond deer and elk to native birds, rodents, species like the sage grouse. Furthermore, the microbiome in the soil takes a very long time to regenerate, and any degradation of the soil is going to have an impact on the soil microbiome. In the deserts, these organisms in the soil, if they're disturbed by construction or enlarging a lot, it takes decades for those soil organisms to be regenerated. And in the meantime, the disturbed area tends to bring in invasive species, which is an issue for the biodiversity of the area. So all these things, I believe, need to be considered before such changes are allowed to be made. Thank you.
Thank you, ma'am. Ms. Brewer?
I have no one else on my list. I did see one hand go up earlier, but I don't see it now. It was for David Arnold. Oh, he's been elevated. Excuse me. He's been elevated. David Arnold is our next and perhaps last, unless someone raises their hand between now and then.
Mr. Arnold, go ahead.
Most importantly, I support Mr. Renuta's claims on the water issues and will be submitting paperwork in support of what Mr. Renuta has said. The thing that we're talking about here is a change to the CMP, and forget I don't have read all the acronyms, but adding 80 new overnight lodging units is a change to the master plan, the final master plan. And I would say yes, it is in my mind. But little things like that, such as selling a 5-acre or a half-acre piece of land to Pinnacle when he shouldn't have been selling property, selling 40 acres of land to Pinnacle that is part of the destination resort in tax lot 7801 is a change in the master plan. So I firmly believe that there are minor changes and there are major changes, and the major changes are committing to sales from Central Land and Cattle Company of Thornburg Resort designated property to Pinnacle Utilities. Now, granted, Pinnacle Utilities is a Cameron Blashman company as well that will provide water. But is that part of that? I would say that's not part of the destination resort process. Those should all, Pinnacle water should be, and the utility should be part of the Thornburg Resort. But making sales outside the scope of the final master plan or the conditional master plan is not correct. So basically, that's and that would be going along with Central Oregon Land Watch's concerns on the last action as well. There's changes to the plan being made by Thornburg Resort Central Land and Cattle Company that should not be allowed. Same as these, and because of that reason, I don't believe that the 80 overnight lodging unit should be allowed to be changed at this point in time. So, and thank you for letting me testify.
Thank you, Mr. Arnold. Ms. Brewer,
There are no other hands raised.
anything you'd like to tell me then? Ms. Brewer?
I do not have anything to add. I'm looking at Will. Will is shaking his head. No, he does not have anything to add either.
All right. Mr. Katzeroff.
Yes, could you please elevate Ken Katzroff, please?
I will try to keep this as brief as possible, but I do have more to say as it relates to this application and the testimony that we just heard. First, I'd like to say that we're not changing the FMP. This isn't a piecemeal development. This isn't playing whack-a-mole every time we come up with a new application. We are directly following the current land use approvals for the CMP/FMP, and we're trying to meet those. So this application before the hearings officer in this particular instance is a modification to change certain discrete issues, and discrete is the term in the code related to ratios, bonding requirements, and other things to meet the code and state law as it currently exists. We are not proposing any changes to the FMP. We are not increasing the amount of individually owned homes. And frankly, we address the applicable criteria to the modification which was requested. Anything else that has been requested by Mr. Kleinman and Ms. Gould is frankly irrelevant to the and is not applicable criteria. So we did our job, staff did their job. We met the applicable criteria, period. We do not need a condition of approval to say that we are going to comply with the final master plan. We have to comply with the final master plan. We're not changing it. So there is no reason to add an additional condition of approval to say comply with the final master plan. That's redundant. We must comply with it. We agree. I want to clarify that Mr. Nuda tends to say that the water permit is expired. It is not expired. We asked for an extension. The department granted it. And upon challenge by Ms. Gould, they sent it to a protest. That protest has not been heard. The results have not finished. And so at this point in time, we have a valid existing water permit that's it, period. A couple of other quick things I want to chat about. I would say that Mr. Kleinman and Ms. Gould know exactly the amount of homes that can be developed. Phase A was approved for 300 single family homes. We're not changing that at all. There's not a change. So I'm a little confused why we're getting spun up on this issue so much. We have a roadmap, CMP and FMP. It's not piecemeal. I want to address two other things, and then I'm going to ask if Mr. Angie, would you mind elevating Cameron DeLashschmidt while I finish this? Two things is that, again, with regards to any conveyance to Pinnacle, those have been corrected, but Mr. Arnold doesn't understand, I think, the code, which prevents a sale of an individually owned lot for single family residence until the OAUs are built. There's no restriction when it comes to facilities, lots, and those sorts of things. It's a different thing. It's apples and oranges. And the last thing I would want to point out is, the resort complies with all wildlife requirements. It was a requirement of the FMP. We have a wildlife plan in particular. We have a fish and wildlife mitigation plan in particular. There is no wildlife issue, although it's not particularly relevant because we have plans in place to deal with wildlife. I would note that there's also no wildlife zoning designation on the property. It is not mapped as a Goal 5 resource for wildlife. And so even if that consideration were relevant, there isn't wildlife mapping. So we comply with the code, we comply with our existing CMP FMP, and we're not proposing a change of that or an increase in residences. If they didn't understand what the application was, again, I'm here to say that it was an application to comport the requirements with state law and local code. It doesn't allow us to increase the amount of single family units, and we meet the applicable criteria. So that's really, I think, all that needs to be said on the issue for me at this point in time in rebuttal. But we have a plan. We've had a plan for 15 years. We're implementing that plan now. So thank you. If I could ask if Cam has anything that he would like to add.
Yeah, thank you again. So one correction. So Mr. Katzeroff just said that we're not acknowledged that we're not increasing the single family homes. We're not. We are asking to reduce the total number of units, the total impact. So There's been lots of comments how we're trying to increase something, and that simply is not the case. Our total number of single-family homes is specified in the FMP. We're not, the application to modify the ratio or the weeks did not change the total unit count at all. So these arguments are all made-up arguments. We're not asking for it. We're saying it. It's not in the materials that we're asking for it. So to be clear, we are not increasing our single-family homes. We are reducing the ratio that will reduce the number of overnight lodging units. The increase from, or the change in the ratio from a 2.1 to a 2.51. So in our phase A, we are required to have 150 overnight lodging units in phase A. And by increasing the ratio to 2.5 to 1 from 2 to 1, our allowed single family homes in phase A would go from 300 to 375. And that is spelled out in materials that have been submitted into the record by Mr. Katzeroff and Ms. Fancher. But we are not in any way increasing the total count or increasing the number of homes. It is just, there is simply a shift from calling something a phase A1 home or a phase B home to a phase A1, a phase A home. It doesn't change the number of homes at all. That's the only clarification I wanted to make. Do you have any questions, sir?
No.
Okay.
Mr. Katzeroff, anything further?
No, I appreciate that. I would say one quick thing, which is that the issue of whether or not things can be phased has been litigated, and we can certainly provide additional briefing on that if as may be relevant at this time.
I've reviewed the remand decision carefully, multiple times. So the phasing issue has been addressed, and I understand that. Mr. Kleinman, your opportunity.
We'll elevate them right now. Thank you. Yeah, please. And Ms. Gold.
Okay, thanks very much.
We lose Craig.
No.
First of all, we okay? First of all,
Yep.
I really can't follow my client very well because she does a great job and she's got the history. But I will do the best I can. I still have very little clue what is actually going on here. And I don't know how much more of a clue staff had, because if what Ken said were true, that, hey, we don't know why the opponents didn't understand it. We and staff are on the same page. Why was it necessary at the outset for the applicant to tell staff that they needed to change some of the conditions in the staff recommendation? So I don't think anyone understands what's going on here. And the conclusion, not conclusion, but the calculation that Mr. DeLashmuth just offered matches what we described in our appeal document and in our memorandum, that they're going up in phase A from 300 homes to 375 homes. And Mr. DeLashmuth implied, but naturally did not state, that the extra number of homes is coming off some other part of the development. But it wasn't even stated. So we are not persuaded that the applicant, again, as we keep saying, has even begun to meet their burden of proof without explaining in this case what the final master plan allows, how it is being changed. And I'm not talking about phasing and subphasing, but what the project looks like under the approved final master plan, what it would look like under the proposed modification that would allow less overnight lodging units, but not more homes, as they explain it. I'm not sure that's really clear. And then you get into issues that some of the witnesses raised that we really need to pay attention to. So if the result, as appears to be the case, is larger lots for homes with more bathrooms and bedrooms and water consumption, much more grass, much more clearing of juniper and the like, and thus a serious change in the wildlife mitigation plan. It's not the fish, this is the wildlife mitigation plan. Then that has to be revisited. But the applicant has not gone back to square one and tied this proposal together with the final, pardon me, with the final master plan, and they need to do that. Otherwise, as we have said, it's a pig in a poke. It may be a somewhat different pig from the one we thought. I don't know that for sure, but I'll say it again, no one really knows what's going on here, and this is not approvable as presented in bits and pieces and parts, and without even a proposed condition of approval limiting the number of total single-family residences that can be constructed, size of lots, analyze vis-a-vis water additional water consumption and the like. You can't just pick things off and reconfigure the development, even if ultimately there are less total units. So the other thing I would mention is we still have the lot of record issue that was raised by Central Oregon Land Watch by Carol Macbeth, and the ramifications of that are as stated in her correspondence, and they affect the ability of the applicant to go forward with further land use applications in this case. Apparently they got caught in these transactions and then tried to undo them, but the legal effect is what Carol says it is. So with that, unless there are any questions of me, I am going to again say, because we are so now even less clear on what the applicant is proposing, and this is not ready for any kind of approval, that the open record period be 14 plus 14 plus 7, and I don't feel that jeopardizes or requires a further extension in the 150-day clock beyond what you already have. Thank you.
Thank you, Mr. Kleiman. Anyone else on rebuttal for the appellant?
Yes, Mr. Hearing's officer. Just a couple of quick points. Mr. Katsarov indicated that there was an extension granted, and he's correct. He failed to indicate, and I'm sure it was just an oversight on his part, that the extension order that granted that extension was withdrawn. So there is no extension. There is simply a permit that is expired and a contested case that will someday be held on whether or not the proposal to extend the permit is lawful or unlawful. The other thing I would note is that, as Mr. Kleiman noted, I'm even more confused now. I heard Mr. Katsarov say that they're still only doing 300. I heard Mr. Delashman say we're going to 375, implying that it was coming from somewhere else. But if, let's assume for the sake of argument, he's right, that's a 25% increase in phase A. That's kind of significant. There's, as my materials addressed, and I won't belabor, there's a huge impact from a 25% increase in single family homes, whether it's in phase A or any other phase. If you're trying to increase the number of things you're putting out there now, you're going to increase the water use. That's going to have an impact on fish. And we'll be happy to submit. There was a comment made earlier in the testimony about the Deschutes Basin groundwater study by the USGS. There's also a recent report by Water Resources that talks about how the aquifers are declining and they're almost out of mitigation water and are going to have to shut down any further appropriation in the basin unless they figure out something else to do because of the dropping aquifers. We'll be happy to submit that Water Resources report in case that'll be helpful for you. That's all I had.
Thank you, Mr. Nuda. Mr. Katsaroff.
Yeah, real quick, 2 points. The first is that again, we're not increasing anything. The entire resort was permitted. There's a final master plan that deals with the impacts to it, including water use. Water use. We're not increasing that. Second, with regards to the permit, again, we disagree. There is a preliminary final order that's being contested. So be it. The effect of the permit is the same. It's not expired. Lastly, Mr. Nuda just referenced that no further appropriation will be allowed. This water's already been appropriated. That's the whole point. We have a valid permit and they're challenging an extension of that permit, but we're not asking for a new right here. So I think I'll end on that, but saying also nearly all of the comments that have been made on this issue aren't relevant to the particular application before the hearings officer, which is a modification for certain discrete issues related to ratios, weeks, and some other bonding requirements, things that the appellant has actually asked for previously. So I'll leave it there. It looks like Cam has one thing to say.
Yeah, just to, there seems to be an awful lot of confusion. So under the code that we applied, there was 2 units of single family home allowed for every 1 overnight lodging units. So we are approved for 950 single family homes. If you divide that number by 2, it's 475 overnight lodging units. We are requesting to change the ratio to the law that is in existence now of 2.5 to 1. So if you take the same 950 single family homes and divide it by 2.5, that's 380 overnight lodging units. That is what we're requesting, is to reduce from 475 lodging units to 380 units. That is a reduction of 95 overnight lodging units. That uses less water, less impacts on wildlife, less pavement, less of everything. That's all I have to say.
Yep. One quick thing I meant to address, I apologize. With regards to our comments of staff being confused, we don't think staff is confused in the ratio. We think that there are some other issues that they erroneously deleted. For example, condition 33. We've articulated those in our memo. I don't think there's anything else to say on it tonight. I'd be happy to chat about the record for what it's worth. Applicant, if the record's going to stay open, I don't see any reason why it needs to be longer than the last hearing we just had. But I'd certainly like to hear the hearings officer's thought.
Okay. I think this, in some respects, granting additional time for the record would simply be granted additional time, but for no specific purpose. Mr. Kleinman, I believe that you've made your arguments clearly. You've heard the testimony tonight with respect to numbers of units. State law doesn't require me to keep it open any more than what I did in the previous hearing. And with that, I think I'm going to stay with the same time schedule. My biggest concern actually is in sympathy of legal counsel for both sides. Because if I take Mr. Katsaroff's comments From the prior hearing, he pleaded hardship of timing, that if that it's a tough month to have to make legal arguments in some respects. If I extended it to Mr. Kleinman's requested time period, there'd be additional time for Mr. Katzeroff and Ms. Fancher to be able to provide its arguments, final argument, without the pressure of having to submit two of them at the same time.
Well,
So I fully appreciate that, but under state law, that's what I'm required to do is follow that. I don't see that there's any compelling reason to extend it. So we're going to stay with the same 12th, 19th, and 29th dates that we talked about in the prior hearing. New evidence will be required to be submitted by 5 o'clock on November 12th. Responsive evidence on November 19th, and final argument on November 29th. Is that clear? Are those dates clear? That's all I'm asking. I'm not asking for a whole bunch of re-argument.
Are you sure?
Okay.
Yeah.
All right,
Well,
Ms. Brewer.
I understand the dates.
All right, Ms. Brewer, you want to go through the logistics again? And I think it's necessary and relevant to talk about how we get information into the record on those appropriate dates.
Yes, we'll do that. Thank you very much. Would you mind putting my PowerPoint back up one last time? All right. So same slide as last time. Has my email address near the top there. Just a reminder for what your record submittals, please remember that the county does not retrieve information from website links or personal cloud storage devices. It is your responsibility to submit all evidence and testimony you want the hearings officer to consider. All submittals must be addressed to me, Angie Brewer, and I will get that to the record and to the hearings officer. For email submittals, my email address on the screen. For those of you on the phone, I will read it. I was realizing earlier that may not have been as visible from the phone. It is Angie, ANGIE.Brewer, BREWER, @deschutes.org. Email submittals that exceed 20 pages or include any colored documents or include any documents that are larger than 8.5 by 11 must also be submitted as a hard copy. Any electronic submittals must be received by the county server by 5 p.m. And please, just a simple request on behalf of staff, please do not wait until the last minute to submit that evidence and testimony. And in particular, in light of the timelines we discussed about submitting on a Friday and scanning it on Monday, the sooner we get it, the sooner we can upload it. I have the dates written down, Mr. Hearings Officer, and I'm prepared to receive that testimony.
Okay, Mr. DeLashman has his hand up.
Yes, I just had one question. So can you give the decision, the date the decisions are due on both?
Well, I'm not going to give you a hard date, but I will tell you that under the agreement that I have with the county, my decisions are due within 21 days of the date the record's closed. I'm really bad at math and I'm not going to go on my calendar and give you a date, but I'll allow.
No, I'm sorry, sir. I was actually asking for the 150-day time.
That was February 12th, was it? February 12th, 2022. All right. Are there any questions regarding the logistics of getting information into the public record? Seeing none, then I appreciate all of your testimony. In these last two cases, it's just a guarantee that I'm not going to make everyone happy, and for that I feel bad. But the requirement is that I follow the relevant laws and rules in this case, apply the evidence, and I will issue a decision appeal rights because somebody's going to be unhappy, appeal rights are going to be in the decision, and you can deal with it from there. I appreciate everyone's attention for these hearings. It's been a long process. You've all done well, and I appreciate all of your testimony. At this time, we're going to close this hearing, and that means that the hearings are completed. Thank you so much.
Yeah.
Good night.
Good night. Thank you.
Thank you.
Thank you, Your Honor.